hearing?
You're absolutely right. All eyes on the Supreme Court on the next course of action. Today, fortunately, everything has passed off peacefully as far as the Jume ki namaz was concerned. It started around 12:30 in the afternoon when the Muslim, namazis started coming into the Gyanvapi Mosque. Before that, we reached here early in the morning and a very large number of Hindu pilgrims kept coming to this place. They kept visiting this place. Remember, it's the same entry point to the Kashi Vishwanath temple and the Gyanvapi premises. It started around 12:30 in the afternoon. By 2:30, it had all passed off peacefully. But one reason for this is also being seen as massive deployment of the Uttar Pradesh police in this area. As you look around, you have the Provincial Armed Constabulary, the Central Reserve Police Force and the UP Police Commandos deployed all over this place. And of course, various volunteer committees, both from the Hindu side and the Muslim side, who were constantly in touch with all community members, elders, leaders, having fanned out into some of these very narrow bylanes. I want to show you there are many such very narrow lanes and bylanes, and not only were volunteers deployed there, but youth from all sides deployed in these areas to ensure that they maintained peace, they maintained calm. Because one message that was going out from here was very simply, the courts will decide, and whatever courts decide will be and has to be acceptable to all. That's the way our democracy works, and that's the narrative that every side is giving out to their people. And if you just see right now, while devotees are coming, others are on their way home. At the same time, other people who've already done their darshan or been to the mosque, they're all going home. Television sets are on to keep an eye on what comes out of the Supreme Court, Akshita. This is the situation on ground as of now. All eyes on the Supreme Court. A very critical aspect today also has been the Hindu side claiming that another shivling has been found at the Gyanvapi Mosque premises. And this is a new revelation first on India today. Images that we'll put out on your television screen will show you two structures. One is what the Muslim side claims is a fountain, and the Hindu side insists is the shivling which was found at the Wazukhana of the Gyanvapi premises. Now, the Hindu side says they found another shivling in the mosque, and they want detailed investigations. I quickly want to cut across to India Today's Nalini Sharma joining us for more on this big story, especially now that this matter comes up in Supreme Court. Nalini, what do we expect in the apex court today?
Well, Gaurav, away from the hearing beginning before the Supreme Court, the bench of Justices D.Y. Chandrachud, Justice Suryakant, as well as Justice P.S. Narasimha are going to be taking up these multiple petitions and multiple applications now that have been filed before the Supreme Court. Not only the two main things that to watch out for during the course of today's hearing is not only what the Hindu side has said, which is something that we've been playing out during the course of the day, but also what the stand of the state government of UP is going to be in this entire matter. At the same time, another important thing to watch out is for as to whether or not the proceedings before the Varanasi court that are essentially the crux of the challenge that is going on before the Supreme Court, is there going to be a stay on those proceedings or not? During the first hearing that had happened before the Supreme Court had categorically said that there will be no stay on the proceedings in the Varanasi court, but had at the same time, within a sense of bringing balance to the matter, had asked for that area where the supposed shivling was found to be protected and to be guarded. But in the second hearing that happened before the Supreme Court, just yesterday, when the Hindu side had sought for a short accommodation to file the submissions and their responses before the Supreme Court was in fact lenient enough to grant one day stay before the proceedings, before the Varanasi court, because of which the survey reports that were filed before the Varanasi court could not be taken up for consideration yesterday. So today, as to what the Supreme Court decides on this aspect is going to be very crucial, because like we know, two survey reports on the entire videography survey that had happened have already been submitted before the Varanasi court. And what remains to be seen is how the Varanasi court is going to react to the contents of these reports, because that is what the main crux of the matter of this entire issue is eventually going to be, what was found in this video survey. So that's very important to watch out for, but that cannot proceed until the Supreme Court gives its go ahead. So as to whether or not a stay is going to be extended today, or whether the Supreme Court is going to allow for the proceedings to go on, is going to be something very interesting, and lots of arguments expected before the three-judge bench today. Just in a few minutes from now, we're expecting for the hearing to kick off.
In a few minutes from now, the hearing is all set to begin shortly. That is what Nalini has been telling us. Gaurav continues to be with us from right outside Gyanvapi. And Gaurav, I'm going to just come to you for you to give us an idea about the current situation. You've been telling us that things are peaceful, and those who've had to pray, wanted to pray, were given an opportunity. In that sense, the Supreme Court in the past has managed to maintain that balance, saying that rights of both sides has to be respected.
Oh, absolutely. Rights of all sides, respected in a democracy. The situation on ground, even as we speak. Let's just walk across. Just till moments ago, there was massive police deployment here because that was the time that the Jummah Namaz was to be offered. But let's walk along, and now you see the police are all heading back to their barracks. Why? Because the situation now appears to be quite normal, and everything on Friday prayers have passed off peacefully. The gate number 4, of the Kashi Vishwanath temple, once again the Hindu devotees going there in numbers to be able to pray. Between 12 and 2, gate number 4 was used. That's the gate in front of you, Sneha. That's the gate that between 12:30 and 2:30 you had Muslim pilgrims who used this gate to go to the Gyanvapi Mosque complex, and then the Hindu devotees used the next access, which is technically the exit, to enter and pray. Now that process is over. It's all passed off peacefully. Now all eyes on the Supreme Court, and of course on this block that you see behind me. I want our viewers to look at the Gyanvapi Mosque structure. This dispute now is about what lies inside this mosque, because the Hindu side very clearly insists that they found another shivling inside the mosque. Now it remains to be seen how the Supreme Court takes this forward, because the Hindu side, Sneha, wants more investigations to be carried out. They say that there is a basement, a tehkhana here. That basement has been walled up there, and those walls, the bricks in those walls appear to be relatively new and not what exists in the other part of the structure. So which means that this area was walled up subsequently, and they want to be able to look what's inside, because they say it buttresses their claim that this was a temple that was demolished on the orders of Mughal Emperor Aurangzeb in April 1669 to build this mosque on top of a temple.
Be with us, Gaurav. Just going to come back to you in a few moments from now. Nalini continues to be with us also. Remember, the court, the apex court, is all set to resume the hearing of the Gyanvapi Mosque case just in a few moments from now. Devotees gathered outside the mosque to offer the Friday prayers. The Masjid committee had appealed to the people to come to the mosque in small numbers due to the sealing of the Wazukhana. In the court, Hindu side has claimed they've been worshipping Lord Adi Vishweshwar, Goddess Shringar Gauri, and other deities for hundreds of years within the property, and that God's property can't be given to anyone. They've also said that Aurangzeb had directed to demolish the temple of Lord Adi Vishweshwar. However, Muslim side says that the claims are incorrect and that there was never a temple. Earlier on Thursday, the apex court stayed the hearing in Varanasi court. The move came from the top court amid fears of the Muslim side that the Wazukhana, where a shivling was allegedly found, could be raised following the order by the Varanasi court to seal the area. Two survey reports submitted in the Varanasi court mentioned an oval-shaped shivling structure in the Gyanvapi Mosque complex. The survey report also reveals a conical structure under the mosque dome, 4 idols in crimson color, temple ruins, and images of deities.
देखिए सुप्रीम कोर्ट में 274 पेज का जो कुछ बहुत शार्ट है, अभी मैंने पूरी बात नहीं लिखी है, बहुत ही शॉर्टकट है। औरंगजेब जब आया था तो उसने किस ढंग से विध्वंस किया था, पर विध्वंस करने के बाद भी पूरा मंदिर विध्वंस नहीं कर पाया था और मंदिर के जो शेष भाग थे उस पर हिंदू बराबर पूजा करते रहे। सुप्रीम कोर्ट में 274 पेज का, जो कि बहुत शार्ट है, अभी मैंने पूरी बात नहीं लिखी है, बहुत ही शॉर्टकट है, वो पूरा जवाब सारे डॉक्यूमेंट्स लगा दिए हैं, जिससे ये शो होता है कि काशी क्या है, काशी का धार्मिक महत्व क्या है। औरंगजेब जब आया था तो उसने किस ढंग से विध्वंस किया था, पर विध्वंस करने के बाद भी पूरा मंदिर विध्वंस नहीं कर पाया था और मंदिर के जो शेष भाग थे उस पर हिंदू बराबर पूजा करते रहे। और अगर किसी मंदिर को आपने तोड़ भी लिया और किसी हिस्से पर काबिज भी हो गए तो उससे वो मस्जिद नहीं हो जाएगी, कि मस्जिद होने के लिए ज़रूरी कि पहले वक्फ हो। विदाउट वक्फ देयर कैन बी नो मॉस्क। ये बिल्कुल इसको कोई काट नहीं सकता।
Nalini is getting us all of those details on what really is expected in Supreme Court today. Gaurav and Samarth Srivastav also continue to be with us. Nalini, to you first. Take us through what could be possibly the submissions before the Supreme Court of India today.
Well, Sneha, before that, just to get you a short update, Justice Chandrachud and Justice P.S. Narasimha, who were till now conducting the normal bench hearings, have now risen from the normal bench, which means that the special bench that is going to be hearing the Gyanvapi Mosque is expected to assemble any moment now. This is going to be a 3-judge bench, including Justice Suryakant, along with Justice Chandrachud as well as Justice P.S. Narasimha. So soon we can expect for the bench to assemble and for the hearing to begin before the Supreme Court. And regarding what is expected today, well, Sneha, there's a lot that's expected today, not only in terms of the arguments that are going to happen before the Supreme Court in this issue, but also what the Supreme Court is going to decide on it by the end of the day. I think the hearing is expected to last at least 1 hour. It might last longer, depending on what the course of arguments is going to happen. But the main thing to watch out for is not only what the Hindu side is going to argue on the aspect of the proceedings that are going on before the Varanasi court, but also what the state of government of UP will say. Because the last time around when the matter had come up, Solicitor General Tushar Mehta, who is representing the UP government, had specifically said that he had not got the papers for the case yet, which is why he could not place the government stand. But the papers were subsequently supplied to him. And today we also expect to hear for the first time the UP government stand on this. And the reason why that's going to be crucial, Sneha, is because Justice Chandrachud in the first hearing had said that they want assistance from the government to help them understand how to proceed with this entire case. So it is likely that the bench might be relying a lot on the stand that is going to be taken by the UP government in the matter, which is why it's going to be a very important takeaway. The second most important thing that is expected, like I was telling Gaurav earlier, is as to whether or not the stay that was imposed on the proceedings in the Varanasi court, although only for 1 day, whether that stay is going to be extended further or not. Because that is what the case of the Muslim side before the Supreme Court is, that the proceedings going on before the Varanasi court are happening without jurisdiction and that those proceedings should not be allowed to continue. So as to whether or not the Supreme Court will agree with that now that they are hearing the matter, or will they allow for the proceedings to go on parallelly, is going to be another important thing to watch out for, because that is eventually what is going to determine how this case is going to pan out, whether there'll be parallel hearings, because that is also a matter pending before the Allahabad High Court. So whether the Supreme Court will put a stay on all the hearings.
I'm going to go across straight to Gaurav Sawant, who's
जैसे हम लोग नमाज पढ़ते हैं वैसी नमाज हुई, हम लोगों की नमाज जैसे हर जुम्मा हम लोग अदा करते हैं उसी तरह से हुई। हाँ, थोड़ी दिक्कतें हुई पानी को लेके, वजू खाने को लेके, जो हमें सरकार से मतलब कि अदालत से ये है कि जल्द से जल्द हमें अस्थायी कोई वजू खाना बना दिया जाए कि जो नमाजियों को दिक्कत, 5 टाइम की जो आते हैं 100 लोग 50 लोग आते हैं उनको दिक्कतें ना हो।
यहाँ आज जो समस्या हुई नमाज को लेकर, किस तरह की समस्या आपको हुई?
देखिए, पहली बात कि जितने भी लोगों को आने के लिए रोका जा रहा है, लोग मैदानी चौराहे से लोगों को रोक दिया गया और प्रशासन ये रोकने का काम कर रही है और बिल्कुल न्यायालय के खिलाफ प्रशासन काम कर रही है।
न्यायालय के खिलाफ कैसे था प्रशासन?
भाई, न्यायालय में मस्जिद पे आने के लिए कोई रोक नहीं था, तो आप प्रशासन क्यों रोक रहे थे न्यायालय में? ये बिल्कुल गलत बात है।
नहीं, लेकिन उन्होंने कहा कि जितनी कैपेसिटी थी उतनी
भाई
कैपेसिटी से ज्यादा
11 बजे ही से रोका जा रहा है। 11 बजे क्या मस्जिद बंद हो गई?
तो फिर कितने लोग, इतने लोग कैसे आए फिर?
भाई आए तो उन्हें रोका जा रहा है, गलियों से लोग आए वो आए, लेकिन जो हम लोग मैदागिन से मैं पैदल आ रहा, बिल्कुल गलत बात है ये।
नहीं तो आप क्या 5 बार आते हैं और 7 दिन आते हैं?
जी हम लोग हमेशा आते हैं।
तो अब आपकी प्रशासन से क्या मांग है?
प्रशासन से मांग है कि प्रशासन क्या करेगी, हमें न्यायालय से मतलब है, और मुझे सुप्रीम कोर्ट का न्याय पे पूरा भरोसा है कि सुप्रीम कोर्ट जो भी करेगी बिल्कुल सही करेगी। लेकिन मेरा ये कहना है कि 1991 जो एक्ट था उस एक्ट के खिलाफ हो गए। आज जो ये वाराणसी न्यायालय ने जो जजमेंट दिया बिल्कुल वो गलत जजमेंट है।
तो ये 1991 एक्ट आप सुप्रीम कोर्ट से क्या उम्मीद रखते हैं?
सुप्रीम कोर्ट से उम्मीद ये करते हैं कि बिल्कुल इसको निरस्त कर देना चाहिए, ये जो याचिका है बिल्कुल इसको निरस्त कर देना चाहिए।
नहीं, लेकिन अगर हिंदू पक्ष ये कहता है कि उनका वहाँ शिवलिंग है तो शिवलिंग के ऊपर वजू
अच्छा
थोड़ी हो
चलिए
सकता
बहुत
है।
अच्छी बात, शिवलिंग अगर वो है तो जो अभी यहाँ पे मंदिर है वहाँ पे क्या था, या तो वो गलत है या तो ये गलत है, दोनों में से कौन सही है? जहाँ ये मान लीजिए वजू खाना गलत है या वो गलत है, कौन सा सही है ये आप पहले बताइए।
ठीक नहीं तो फिर इसका सोल्यूशन क्या है? इसका सोल्यूशन क्या निकल सकता है आप लोग की दृष्टि में?
इसका सोल्यूशन हमने बाबरी मस्जिद दिया सोल्यूशन में, अब मैं मस्जिद नहीं दे सकता, सोल्यूशन में एक बाबरी मस्जिद दिया हूँ, भाई न्यायालय जो करेगी मैं उसे मानूंगा।
तो न्यायालय जो कहे वो आपको मान्य होगा?
जी न्यायालय जो कहे मान्य होगा।
और इस समय शांतिपूर्वक सब रहा, उसको आगे शांतिपूर्वक रहे कैसे इंश्योर करेंगे?
आगे जैसे अभी हुआ है वैसे पहले भी होगा, बाद में भी होगा।
तो नजर सभी की सुप्रीम कोर्ट के इस केस पर है। एंड यू नो दीज आर सम ऑफ द नमाजीज हु ऑफर्ड नमाज हियर दिस आफ्टरनून। दे वर एबल टू प्रे। सम ऑफ देम सीम टू इंडिकेट दैट दे हैड सम इशू accessing the Gyanvapi Mosque to carry out their prayers. They could not do wuzu here because they didn't have access to water in some parts of this. Others say that they also want unhindered access to their mosque. Now these are both the issues that the Supreme Court will look into. Once again these people are raising the point of the 1991
Court has resumed the hearing of the Gyanvapi Mosque, the controversy around it. Remember, the matter is now in Supreme Court, but the Muslim side moves Supreme Court. The argument of the Hindu side is that where is the mosque, essentially, given that even a waqf was not created. There was no creation of a board in that sense by Aurangzeb. So Gyanvapi is not a mosque, is what the Hindu side has in fact told the court in the past. I'm going to go across again to my colleague Gaurav, who continues to be with us on that. The argument, Gaurav, in fact, Nalini will also be joining us in a few moments from now. Nalini is with us, in fact. Nalini, the arguments of the Hindu side again has been that the creation of a mosque is followed by the creation of a waqf board. In the case of Gyanvapi, that never really happened.
Well, precisely, Sneha. And in addition to what you just said, they have also gone ahead and said that before a mosque existed at the place where the Gyanvapi Mosque is, there was the Adi Visheshwara temple that was there already existing. And that Adi Visheshwara temple was demolished in part, and using the remaining structure of the temple, a mosque was constructed in that place. So essentially what they are trying to do is trying to establish the religious character of that entire premises as that it was originally a temple, which was then later on subsequently converted into a mosque using the partially demolished structures on the temple. What they are also saying is that because there was no creation of a waqf in this matter, so the structure cannot be called a mosque in itself. It has to be referred to only as a structure. But also, just to get you a quick update from what's happening in the Supreme Court, the 3-judge bench that's hearing the Gyanvapi Mosque matter has now assembled. The hearing is currently underway before the Supreme Court. And what we know is Senior Advocate C.S. Vaidyanathan, who is one of the top lawyers in the Supreme Court, is representing one of the women petitioners who had originally approached the Varanasi court before the Supreme Court now. So one of the 5 women, Hindu women, who had approached the Varanasi court asking for the premises, for the videography to be conducted and for the premises ultimately to be sealed, are now also party to the proceedings before the Supreme Court, and Senior Advocate C.S. Vaidyanathan is representing them. The arguments are currently underway, but before the arguments have started, Justice Diva Chandrachud has laid down certain suggestions for the proceedings. He said that the application on the maintainability of the issue that is pending before the trial court, let that be heard in the meantime, so that contentions on both sides can be kept open and the Supreme Court doesn't have to get into every aspect. He's also gone ahead and said that they will pass some interim orders today, creating some sort of arrangement so that this issue of maintainability is dealt with. Sneha, let me quickly just explain to you what the issue of maintainability is. Before any matter can be heard on merits, a court has to decide whether or not the court even has the jurisdiction to hear the matter. That is what the maintainability of the suit is called. So as to whether or not that suit can be maintained in the court. That was the case of the Muslim side when they approached the Supreme Court, that there was no maintainability in this case and that the Varanasi court was hearing this matter without jurisdiction. So at that time, the Supreme Court had suggested that they can send the matter back to the Varanasi court to first decide on the issue of maintainability. And in case they see that they do have the jurisdiction to hear the case, then they can of course go ahead and hear the matter on merits. So it seems like the Supreme Court is decisive on doing that and making that happen, which is why they are saying that let the Varanasi court hear the matter on the issue of maintainability at the same time, so that it's not the Supreme Court that has to delve into every minute aspect of the matter. These suggestions have come in from the bench before the arguments have begun, and we'll keep a close eye on how the proceedings are going to progress, because the Supreme Court's made it clear that there will be an interim order that will be passed today. So it seems that the Supreme Court decision to a certain extent on what the stopgap arrangement while the Supreme Court's hearing this matter is going to be extremely crucial to watch out for today.
Yes, absolutely. Be with us, Nalini. I'll just come back to you for more on that. I'm also going to be bringing in senior editor Preeti, in fact, is with us here in the studios. Preeti, the fact of the matter is that the court essentially has said that let the place where the shivling was found be sealed and that the rights of both sides must be respected. But certainly the Muslim side, at least some, are not happy with the arrangement that has been put in place.
You know, ultimately it's going to be the law over faith, Sneha, and that is going to be pretty much which will go down in terms of the letter of execution of what happens next. All eyes, as even Nalini pointed out right now, the Supreme Court hearing has resumed. And if we just give a bit of a background, yesterday the Supreme Court was to hear the petition which primarily challenged, let's go back how it all happened, because the junior court, the lower court in this case, the Sessions Court in Varanasi had gone ahead and ordered a videography survey of the Gyanvapi Mosque. Now that was challenged in the Allahabad High Court. The Allahabad High Court turned it down, saying very clearly, and we can cut across to Nalini as well on this, that the Sessions Court is completely allowed to go ahead and order a survey. Nowhere does it hinder into the 1991 Places of Worship Act. But at that, since then, till now, what really happened was that the Supreme Court, when hearing this particular plea, went ahead and in terms of the area which was cordoned off, which was sealed, where the claimed shivling has been found, it went on to protect that order of the Sessions Court. Now that has given multiple interpretations. Number one, Nalini can also add more on that. Has the Supreme Court recognized the fact that there is indeed a shivling? And if it has recognized, then it opens a completely new case altogether. On the other hand, yesterday was when the hearing was to be resumed. Now the Hindu plaintiff asked for more time. So all eyes practically on the Supreme Court today, Sneha, what the Supreme Court does today, what it says today. Will it once again say that it will continue to hear the plea, because there are more petitions right now. It's not just the Gyanvapi Mosque. You had something yesterday where the Mathura lower court was concerned. Will it say that we will continue to hear the plea and the proceedings in the lower court will be on hold? We'll only know what the court does, but huge impact, huge implications.
Preeti, be with us. A quick update from the court. I'm going to go across to Nalini for more on that. In fact, Nalini, break this down for us. Advocate Vaidyanathan has spoken about the Muslim side and their plea, saying that it's the plea can't be maintained. What else can you tell us about what has been said in court right now?
Well, Sneha, like we were stating earlier, the Supreme Court's made it clear that they are in favor of parallel proceedings going on before the Varanasi court, because what Justice D.Y. Chandrachud has just said is that the issues like that of the commission report, and now that there are two reports filed, The district judiciary is well equipped to handle that. He says that there are senior judges in the district judiciary and they know how to handle these commission reports, which is why the Supreme Court is in favor that the hearing before the Varanasi court should be allowed to continue. There are, of course, objections being raised by the Muslim side because their main point of contention is that there is no maintainability in this matter and that the Varanasi court does not have the jurisdiction to hear the case. But what Justice Chandrachud is suggesting, that if maintainability is an issue, that they can always ask the district court to first decide on the issue of maintainability, whether they have the jurisdiction, and then hear the entire case on merits. What he's also said is that they are not casting any aspersions regarding any judicial officer in this case, but what their suggestion is maybe the best way forward for the court to go into these proceedings. Justice Chandrachud has also gone ahead and said that parallel inquiry may have to be conducted in the matter to decide whether or not the suit is maintainable. So while the Supreme Court has already taken note of the matter, there is no reason why the hearing cannot go on parallelly before the Varanasi court as well. What the Muslim side, represented by Senior Advocate Ahmadi, is stating before the Supreme Court is that all of the orders that have been passed by the Varanasi court ever since this 3-member commission, which has now come down to a 2-member commission, was formed, all of these orders have been done so without jurisdiction, and therefore all of these orders should immediately be first put on stay, and only then should the Supreme Court delve into what to do now. So without
Gaurav, in fact, be with us, Nalini. Gaurav, the court, in fact, has been told just now by Advocate Ahmadi, arguing for the Muslim side, that these orders passed by the Varanasi court are capable of causing great public mischief. There is a concern that this could create a law and order situation. And we've seen, you were in fact in conversation with a few people who said that what really is happening is unfair.
So if there is a law and order situation, there is a law and order mechanism to deal with the situation. One part. Second part, there are two sides to every story. If one side says this is a violation of the 1991 Places of Worship Act, there is another side that says that 1991 Places of Worship Act is a violation of their right to worship, their right to reclaim their places of worship. All of this matter will be decided by the Supreme Court, and the matter is in the Supreme Court. The Supreme Court is hearing both sides and all sides. The Supreme Court has also made it very clear that the district judiciary comprises very learned men. They are very senior judicial officers, and we should leave it to their wisdom to move forward on this case as they may deem fit, and they will not interfere or give any direction to the district judiciary. So it is proceeding as per law of the land. The people have spoken to on ground. All sides say the matter is in court, and it is for the Supreme Court to take a decision. Once the courts decide, court orders will be accepted by all sides. This is the Hindu Paksh saying that. I spoke to a large number of Hindu devotees. It's the Muslim Paksh or the Muslim side that's saying that, and we spoke to a large number of Namazis, not one, not two, and not just political leaders, but members of the community and those who are a part of the Masjid Intizamiya here at the Gyanvapi structure. So very, very clearly we are speaking to all sides, and it is for the judiciary then to take a call to move forward.
Yes, and this matter again, Preeti, is being heard in the Varanasi court as well. Of course, it's due on the 23rd of May. But just explain, Preeti, how is the case in the Varanasi court different from what is being heard in Supreme Court right now?
Well, the Varanasi court right now, Sneha, has been hearing a case by 5 women petitioners who want access to the compound of the Gyanvapi Mosque, because they go there and pray twice a year during Navratri to Ma Shringa or Gauri. Now, twice a year, the mosque compound is open to devotees to come and offer the prayer. Now, 5 women petitioners who come not just from Varanasi, but from various corners of India, have come together and lodged a petition that they want access to the premises of the mosque through the course of the year. And on the basis of that plea, the Sessions Court then ordered a videography survey to ask and appointed a commissioner who was, of course, there was contention against him, that a videography survey needs to be conducted to actually gauge whether there are Hindu relics inside the particular mosque. Now, that was contended. The videography survey was contended by the Muslim side, by those administration of the mosque. They approached the Allahabad High Court saying that a videography survey of the Gyanvapi Mosque contends as in conflict with, now that we've spoken so much about it, the Places of Worship 1991 Act. Now, the Allahabad High Court at that point of time had held, no, it is not in contention of the 1991 Places of Worship Act. How does a videography survey come in the way of that? And that is when the Allahabad High Court had quashed the plea. So the Muslim petitioners from the administration side then approached the Supreme Court with the same. Now, what has changed from the Allahabad High Court's order to the Supreme Court's, the plea being heard now by the Supreme Court is that in the interim bit, the Sessions Court, the Varanasi Sessions Court, which has continued to hear the order, passed another ruling which gave fodder to the Muslim petitioners to then go and tell the Supreme Court that, listen, now it interferes with the 1991 Places of Worship Act. Now, what was that order that was passed by the Sessions Court, which is the Varanasi Court, was to cordon off, to seal off the area where a claimed to be shivling was found and by the videography. So, by the virtue of doing so, that is what is now being contended also by the Muslim petitioners, who say that, listen, now this, the very fact that you have completely sealed off the area of the Wazukhana interferes of our right to offer prayers, which is in conflict of the 1991 right to the Places of Worship Act. So that is the operative part that is practically changed. So the main difference, what is being heard in the Supreme Court and what is being heard in the Varanasi Court. The Varanasi Court, it's a petition by 5 women who want access to the Shringar Gauri, the deity or the area where they pray, which is inside the compound of the mosque. They have access to it twice a year. They want access to it through the course of the year.
For our
Different in
viewers,
the Supreme Court.
Yes, Preeti, be with us. For our viewers, in fact, I'm going to go across to Nalini again. The Muslim side, Nalini has been arguing that there's been a pattern to all of this, with Advocate Ahmadi saying the issue is what's happening on the ground, and that notwithstanding the verdict of the Ayodhya case, if this is going to be allowed to fester, then what the court wanted would be a pipe dream, is what Advocate Ahmadi has said. Also saying that developments in this case are being repeated in a handful of other mosques across the country.
By the Muslim side right now during the course of arguments, where Ahmadi, who's representing the Muslim side, senior advocate, has argued that there is a law and order situation that is being created on the ground because of the orders that have been passed by the Varanasi court. What he's also gone ahead and said that he is challenging the order that had first of all instituted the commission itself, because what this commission has done is that even before the reports were submitted before the court, the reports were selectively leaked to the media. So there is an attempt that the Muslim side is alleging that there is an attempt to create a certain narrative within the media and through the media within the society, so that this entire issue can be decided at an earliest, and this is causing a law and order situation on the ground. What he has also gone ahead and said is that this issue is being repeated with this example of what's happening in the Gyanvapi Mosque. It's something that has been replicated in 4-5 other mosques across the country as well, which is essentially why he's asked for a stay on all of these orders before the Supreme Court goes ahead and conducts a detailed hearing on this issue. One thing that the Supreme Court bench has made very clear is that the hearing is not going to go on for very long, because it's the last working day of the Supreme Court before they break for the summer vacation. So by 4 p.m. is when Justice Chandrachud has indicated that he would like to wrap up the hearing, which is barely 25 more minutes. So
Nalini, be with us. I'm just going to get in Gaurav as well. Gaurav, in fact, the Muslim side has spoken about these issues, that there is a pattern to all of this and that there is a possibility of a law and order situation.
So the police will deal with the law and order situation, and if there is a court order, then everybody, has to follow a court order. On Preeti's point about places of worship act, if Wazu is stopped, remember Wazu was stopped and yet namaz was offered today, and not by 1, 2, 3 or 20, but over 700 Muslims at the Gyanvapi Mosque. So, they did their wazu, an alternate location was found, they did their wazu and they offered namaz, and they have been offering namaz. Today was just a bigger namaz, the Friday Jummah namaz, but other namaz is also being offered, and not just here, but multiple other such locations. That's point one. Point two, it takes two to tango. If the Muslim side says this is the Gyanvapi Mosque, there is a Hindu side which has for very long been saying this is the Kashi Vishwanath temple, and Aurangzeb destroyed the Kashi Vishwanath temple and built a mosque on top of it. Now they want to reclaim their temple based on certain new evidences that have come to light. Those evidences have now been videographed, documented and presented in a court of law. They will now be analysed and interpreted by a court of law and an order passed. Simultaneously, there is an effort being made to find an amicable solution, because if you were to move on places of, on law, a mosque, again, this is being argued, and we had, Rubina Khanam of the Samajwadi Party on India Today on my show India First, who said a mosque can only be built on a place which is either virgin territory, which means no other structure should be there before, a place that has been bought, it cannot be taken, by force, or a place that has been donated. Only these three aspects is where a mosque can come up. According to Rubina Khanam of the Samajwadi Party and several Muslim clerics subsequently, does the Gyanvapi fulfill all these criteria? And not just the Gyanvapi, but also, the Mathura Sri Krishna Janmabhoomi, again, something that has been talked about in courts of law. So these are all issues that will be dealt with in courts of law, and then a subsequent decision will be taken.
Be with us, Nalini. There's an update from court where the court has said that a framework was created and that we want to hold the balance.
Yes, in fact, Sneha, very important update coming in from what Justice Chandrachud has just said. He has said that with the view of maintaining balance, he said that we cannot stop the district courts from functioning, and we will not direct the district judge as to whether or not he should consider and accept the report of the commission. This is something that Justice Chandrachud had spoken of earlier as well, where the Supreme Court should not be directing the district judiciary on how they should function. And in that reference, he said that there are very senior judges who are part of the district judiciary as well, who very well know as part of their job description on how to handle commission reports like this and what all needs to be considered while taking up such report for consideration. So the Supreme Court's made it very clear that they will not be directing the district judiciary on what to do with this matter, and they'll leave it up to the wisdom of the senior judges in the district judiciary to decide exactly how to proceed with this commission reports that have now been filed before the district court. So it doesn't seem likely, of course we can't speculate at this point because the hearing is still underway and the orders have not been passed by the Supreme Court yet, but it doesn't seem likely that the Supreme Court is in favor of extending that one-day stay that they had granted over the proceedings that were going on before the Varanasi court, because they seem to have a lot of faith in the district judiciary that's hearing this matter, and they would like to leave it up to their wisdom to decide exactly how they should proceed. But at the same time,
court has said, Nalini, be with us. Gaurav, in fact, is with us as well. The court there is saying that inclined to allow the district judge to hear the issue on whether the civil cases are maintainable, and also a framework is being created, so there shouldn't be a problem, Gaurav.
So the Supreme Court making this very clear, and this is what Justice Chandrachud has been saying from the beginning. First, let's have a framework and then move forward. As far as directing district judiciary, as is one of the prayers, is concerned, they very clearly said the district judiciary, very senior judicial officers, they know their job, they know the law of the land, and they will take actions accordingly. Whichever side is unhappy with the decision can then use the due process of law as given in the Indian Constitution to approach a superior court. And if they're not happy with the superior court, they can approach a bigger bench, whether of the High Court, or then ultimately come to the Supreme Court. So all of this is being dealt with, by the Supreme Court, laying down the framework to move forward. on a very contentious issue which will not just remain restricted to this Gyanvapi premises, but will also subsequently in the years or times to come extend to the Sri Krishna Janmabhoomi in Mathura. And there's a new case that has come up in Bhojshala in Madhya Pradesh, where once again the contention is that Ma Saraswati's temple was demolished and a mosque or a dargah created in that area. So the Hindus there want restoration of prayer rights.
This is an argument that has been made by the Muslim side in court just now. Give us an idea about what exactly is the court said on the Muslim side, suggesting there being a pattern to all of this and saying that this is happening in 5 to 6 mosques across the country.
This indeed is the case. So, if you look at what's happening in the national capital, you look at Qutub Minar or the Quwwatul Islam Mosque. That Quwwatul Islam Mosque in the national capital, the story now goes that there is a 1,200-year-old nursing an avatar of Lord Vishnu. His idol has been recovered in one of the pillars there, rescuing Prahlad. This is an old temple there, which of course the Archaeological Survey of India also acknowledges. A large number of Hindu devotees now coming here for darshan at the Kashi Vishwanath temple. Some of them had been advised at that point of time not to use this access between 12:30 and 2:30. An amicable resolution was found. They either came from the other side or are now coming in larger numbers today. And similarly, there's a case with the Taj Mahal or Tejo Mahalai, which the High Court had thrown out, and rightly so, saying carry out your investigation, do your MA, PhD, do your research, and then come with facts. So again, it will be on the basis of facts and not faith that this case will move forward. It's not faith versus law, it's facts taking the law forward.
Well, absolutely. More updates from the court, and I'm going to go across again to Gaurav for more on that. Gaurav, in fact, the Muslim side is also arguing that the situation is going out of hand. It's already amok, is what has been said by Advocate MD.
So that is their contention, and that was the contention of, you heard when I spoke to some of the, namazis here, and that was on live TV, because one of them was telling me earlier that whatever we may want to say, how do we know it will be broadcast? So I said, you're live on India Today and Aaj Tak, just say what you want to say. And their point was that initially they were under the impression that after the Ayodhya verdict, it will only be the Sri Ram Janmabhoomi Ayodhya and nothing else. And now they're saying that Kashi, Gyanvapi, and then Mathura Sri Krishna Janmabhoomi will then open a Pandora's box in a country where you have multiple religions. So what's the way forward? And then again, within the community, there are some who are coming forward to say that the significance of Mathura, it is the Yogeshwar Sri Krishna Janmabhoomi. If there is a Hindu faith, belief that Sri Krishna was born there, that temple cannot be shifted anywhere else. But the question that they are asking their Muslim brothers is, what is the significance of the Eidgah at that location? Similarly, what is the significance of the Gyanvapi Mosque at this location, where the Hindus believe that the Jyotirling emerged here? So again, there are many aspects that will be discussed in courts of law, for the courts of law in their wisdom to take a decision to move forward.
Yes, the court, in fact, importantly, Gaurav is talking about the need for a healing touch right now, with Justice D.Y. Chandrachud also saying that we intervened in this matter because we thought that it's going to be like a healing touch for both sides. An important statement from the Apex Court today.
You're absolutely right. The court is also talking about the healing touch at this point of time. But what will that healing touch actually be? What is the way to move forward? There is a lot of conversation that's happening, observations that are happening in courts of law. The verdict could well be very different ultimately when it comes, or the interim order that is passed. We will still have to wait, Sneha, for what the learned judges, and since this is a division bench comprising 3 very senior judges of the Supreme Court, they will in their wisdom decide the next course of action and pass an interim order for the process to continue. In fact, even here in Varanasi, the wait is for the Supreme Court either to issue a direction or shed light on how best to move forward, because there are several other petitions now in the light of new facts emerging with the petitioners now seeking more access in terms of being able to pray at the place where the Hindu side insists they found, where the Hindu side insists that they found a shivling. What is also being said, again a story that we are breaking first here on India Today, is that a second shivling has been found in this area, according to the Hindu side, buttressing their case that this was a temple that was destroyed in April 1669 on the orders of Emperor Aurangzeb to build a mosque in this area. So there is this debate that's now raging about reclaiming places of worship versus, as some argue, the Places of Worship Act 1991.
Yes, Gaurav, be with us. Preeti, in fact, the very fact that the matter was in fact brought out before the press in the form of a leak report is something that the Supreme Court is not very happy about and has spoken about it as well.
Well, you're right there. Also, you know, the fact about the Places of Worship Act, Sneha, the fact that it was contended to in the Supreme Court was not my point, but it was the point of the Muslim side that they were making. And ultimately, it's not going to be spokesperson of the Samajwadi Party, the Congress, the Bharatiya Janata Party that are actually going to have any bearing on what the court does. It's going to be law over faith, and that's quite clear. It's not going to be on the ruling of passion. But yes, the court hasn't taken kindly at all. And I'll go back to the history of what really happened. Earlier on, what was the main contention also in the court was the fact, in the lower court was the fact that the Muslim side wasn't quite happy with the advocate commissioner who was conducting the videography survey. They said he was biased. Now, what also went down is, and I'll give you a first-hand information, is that the lower court upheld that and saying that no, he's not biased, but what we will do is we are going to attach in good faith one junior and another commissioner of the same level at Mr. Mishra, who was the AC, who the Muslim side said was being biased. So they attached 2 more commissioners to that. The day 1 of the survey, Sneha, how did the media actually get to know of what really went down in terms of what was found in the videography evidence which was being documented in the survey was when Mr. Mishra actually came out, and when we spoke to him, he said, and I'll quote him, कि survey गोपनीय है. That means the survey is supposed to be sealed. It's a secret. But he also added, उम्मीद से ज़्यादा देखा. That we saw a lot more than we were expecting. And then that completely rolled into many, various versions of what was inside coming out. And after that, there has been a repeated leak that has been coming in from the commissioner's side. That today, clearly, where the Supreme Court is concerned, being contended with, that they were not quite happy with the constant leaks in the videography survey that went down.
Yes, Gaurav, also the court, in fact, right now is being presented with an argument on the Muslim side, where Advocate MD is saying that the entire area of the Wazoo has been sealed, expressing concerns and saying that the status quo of 500 years has been altered. So it's not like the status quo has not been changed.
Well, the Wazoo area has been sealed because the petitioner of the Hindu side rushed to court saying that there was an apprehension that place which the Hindu side insists is the shivling could be destroyed. That was his apprehension, and he said there could well be material loss of evidence in his case. So to ensure that there is no material loss of evidence in his case that could put forward his petition in the case, he has then moved that moved court for sealing of that area. That sealing off of that area is a temporary measure and not a permanent measure. Namaz was still offered at the mosque. Worship was still done at the mosque by the Muslim side just a couple of hours ago, and they continue to worship at the Gyanvapi, and very amicably this situation is being resolved. So there is fear. There is also fear-mongering, and it is in the wisdom of the court to decide what they will do to ensure that both sides are not disappointed.
So to tell our viewers, the court has suggested the matter can be kept pending. It's a suggestion that's come in from the court as we speak, while the issue on maintainability is decided as what the Supreme Court has suggested, with Justice Chandrachud telling the Muslim parties if the issue of maintainability is decided against you in the district court and high court, come to us. Nalini, I'm going to come across to you for a quick word on what has just been said by the Supreme Court on the fact that the matter can be kept pending.
Well, Sneha, what the Supreme Court has suggested, like they suggested the first time around, is sending the matter back to the district court for it to be decided on the issue of maintainability. And they've told the lawyers for the Muslim sides to keep an open mind, because in case they lose on the issue of maintainability before the district court, they can always challenge the same before the High Court. And if they lose the same before the High Court as well, then the Supreme Court has given them the liberty to challenge the issue of maintainability before the Supreme Court as well. But what they don't want to do is take away the powers from the district court and the High Court to do the job that they are meant to do and do an overlapping of court hearings, which is why they want to have the faith in the district court to be able to decide this issue in finality through their own wisdom, which is why they're saying we'll send the issue back to the district court to decide on the issue of maintainability. And if you're not happy with that and you're also not happy with what the High Court says, you can always come back to us. We'll keep the matter pending with us and we'll take it up as and when you approach us.
Court also has expressed concerns about, the vazu remain obstructed. Remain obstructed is what Justice D.Y. Chandrachud has said. If according to you, even after our order, the vazu remains obstructed, we can pass the order to make arrangements essentially. That is an option, Gaurav, that the court is leaving open right now.
You're absolutely right. In fact, that's an option that the court is considering. That's an option that the administration is considering. And when I spoke to Masjid Intizamiya here at Gyanvapi, they said that alternate arrangements are being made for wazu, because before wazu, namaz cannot be offered. So while there is a contention, and this is a very major contention of the Hindu side, I mean, they're saying that the place where the wazu khana was actually where the shivling is, and that is why they want more investigation. So once this fact comes to light, can you still have the wazu khana in that location? And we all well know what happens at the wazu khana. You wash your hands, you wash your feet, you clean your mouth, and once you clean up, then you go and offer namaz. But where is that being done when the Hindu side is claiming that this is where the shivling was? So, that is why the trial court or the appropriate judicial forum ordered the sealing of that place, and an alternate location for wazu khana is being worked out. Now, that is how the court is perhaps looking at in terms of moving forward to find a solution to a situation, to a problem that actually started with Aurangzeb demolishing a temple in 1669. And there are other such temples where one side now wants to reclaim their places of worship. Can their right to reclaim their places of worship be barred by a 1991 act that bars them from reclaiming their places of worship? That again would be decided at an appropriate forum, whether it's the Supreme Court or an act of parliament. We'll continue to report on that story, Sneha.
Yes, Gaurav, once again, to what the Muslim side has said via Advocate MD, that the Places of Worship Act was created to prevent the controversy arising due to change in religious character, something to which, Justice D.Y. Chandrachud has replied, saying that we got the prayers of the earlier suit. Do clarify that point for us.
So the Places of Worship Act very clearly did state in terms of what the religious nature of a place that existed as on 15th of August 1947 when India became independent would remain per se. But even then, while the Narasimha Rao government passed the Places of Worship Act in 1991, the opposition at that point of time, which is the Bharatiya Janata Party, continued to oppose it, saying that in case this goes to a court of law, it would be challenged. And while it didn't go to court earlier, it has now been challenged in courts of law with the petitioners saying that, one, while the Ayodhya dispute was kept out of it, since that predates it, they are saying Kashi Vishwanath and the Sri Krishna Janmabhoomi are ancient structures and they too do not fall under the purview. Now, that is their contention and would be decided appropriately either by court or in case it is challenged, subsequently in courts of law. So they are saying that, one, it's bad in law. Two, it takes away from their right to reclaim their places of worship, especially something as significant as the Sri Krishna Janmabhoomi at Mathura and the Kashi Vishwanath temple here, the Gyanvapi premises here in Kashi. Sneha.
Preeti, I'm going to come to you for more on what has been said by the court as we speak with D.Y. Chandrachud, Justice D.Y. Chandrachud, arguing that We had tried to interpret the Places of Worship Act in the Ayodhya judgment as well, but the nuances that the court today is choosing to not get into.
Well, you know, what is really interesting is, you know, and Sneha, it's interesting to give context there, and Nalini, you could add to it if you want, is the fact that Justice Chandrachud was part of the 5-judge bench that gave the historic Ayodhya judgment and the verdict. He was one of the authors of the copy of the Ayodhya land dispute verdict. And he says, we have tried to interpret this in our Ayodhya judgment, but there are various nuances which we don't want to get into at this stage. And understandably, there are nuances. Understandably, where the Places of Worship Act 1991 is concerned, there are various facets, various aspects that could very well challenge the law itself. But alongside that, there is also the Ayodhya judgment, which Justice Chandrachud has written. So, you know, in context, all of it, if you read into it, it's extremely interesting, and it all depends in which way the learned bench is going to go now. It seems that they're going to continue to hear the petition, but of course, at least by the language that is coming in. And what also would be interesting, Sneha, at this juncture is, because till now the Supreme Court had, what was happening in the Kashi court, it had stayed the proceedings there. Now what happens is going to be interesting.
Gaurav, repeatedly the argument that the Muslim side has been in court today that what has been done is unfair. The Wazu area has been obstructed, and that's the reason why the right to worship has been interfered with, is the argument that is being made by the Muslim side in court. The court is suggesting that what they tried to do was a balancing act, but the Muslim side obviously has said that it's really not working on the ground.
Well, it worked on ground some ways today. Wazu was conducted at an alternate location, and namaz was offered by more than 700, according to the Masjid Intizamiya themselves, that they claim, at least they claimed initially, that there were more than 700 namazis inside already. Point 1, point 2, you know, so one side says that it is unfair, they're unable to do wazu in the mosque. The other side says it's unfair, I'm unable to pray, I'm unable to access Lord Shiva's, the shivling or the Shringar Gauri Sthal. They are saying I'm unable to access certain other Hindu symbols that have been found inside a mosque. Now, will those structures be otherwise inside a mosque?
We're going across to these pictures of Navjot Singh Sidhu that has come in. Remember, Navjot Singh Sidhu had tweeted yesterday that he would submit to the majesty of law, and this morning it did appear that he would surrender at a court in Punjab's Patiala. These are pictures of Navjot Singh Sidhu coming in right now, where he had previously requested that he will surrender, but had wanted some time on held grounds. This a day after, remember, the Supreme Court sentenced him to 1 year in jail in a road rage incident in which a man was killed. This is, in fact, this incident is from 30 years ago. This was a 34-year-old case where Sidhu had, in fact, in a road rage incident, was convicted by the court. He is, in fact, surrendering as we speak. These are pictures live first on India Today of Navjot Singh Sidhu right now, who is surrendering. Previously, it sought more time on held grounds, but now he is surrendering a day after the Supreme Court sentenced him to 1 year in jail in a road rage incident in which a man was killed 34 years ago. Surrendering in a court in Punjab's Patiala, where the Supreme Court just yesterday had ordered 1 year rigorous imprisonment for the cricketer turned politician who had just recently quit as the Punjab in charge of the Congress party after the defeat of the party in the elections. Sidhu, remember, has been convicted in a case which is from 34 years ago. In fact, this was a road rage case in which a man was killed in a road rage incident involving Navjot Singh Sidhu. The court has ordered 1 year rigorous imprisonment for Sidhu, and he's surrendering. Let's listen in to what he said. Navjot Singh Sidhu surrendering in a court in Patiala when the Supreme Court has ordered 1 year rigorous imprisonment. The quantum of punishment has been ordered by the Supreme Court to Navjot Singh Sidhu, who was involved in a road rage incident from 30 years ago. A man was killed 34 years ago, and this road rage case involved Navjot Singh Sidhu. The court has convicted him, also ordering the quantum of punishment of 1 year imprisonment. Previously, Navjot Singh Sidhu had sought more time to surrender, talking about his ill health, and was seeking more time. However, he has now decided to surrender. He is doing so at Punjab's Patiala as we speak. These are pictures of Navjot Singh Sidhu surrendering before the Patiala court. He previously sought time from the Supreme Court to surrender, and the Chief Justice of India had refused to entertain this plea. Sidhu, remember, has been sentenced to a year's imprisonment in connection with the 34-year-old road rage case. Pictures on your screens are of Navjot Singh Sidhu, who is in fact surrendering at the Patiala court right now. My colleague Satendra is getting us more details on that story. Satendra, Chief Justice of India ने ये plea सुनने से मना कर दिया था. वो टाइम मांग रहे थे, कह रहे थे कि मेरी तबीयत नहीं ठीक है, लेकिन वो अलाउ नहीं किया है और आज सिद्धू सरेंडर कर रहे हैं.
देखिए, सिद्धू सरेंडर करने के लिए पटियाला जिला अदालत में पहुंच चुके हैं. तस्वीरें मैं आपको दिखा रहा हूं. इस रास्ते को बंद कर दिया गया है. अभी सिद्धू का काफिला पटियाला जिला अदालत में पहुंचा है. और ये मैं आपको बताना चाहूंगा कि जिस तरीके से नवजोत सिंह सिद्धू ने सुप्रीम कोर्ट में प्ली लगाई थी और किसी तरह की राहत उन्हें नहीं मिली, उसके बाद बाकायदा सेशन जज ने उनके वकील को बुलाकर कहा कि अगर सिद्धू साहब सरेंडर करते हैं तो वो जल्दी अदालत में आए या फिर उनको कार्रवाई करनी पड़ेगी. उसके बाद सही 3:50 पर नवजोत सिंह सिद्धू अपने घर से निकले हैं और अभी सही 4 बजे वो पटियाला जिला कोर्ट में पहुंच चुके हैं. यहां पर उनका सरेंडर का प्रोसेस शुरू होगा, जिसके बाद नवजोत सिद्धू को सीधा पटियाला जेल भेजा जाएगा और उससे पहले उनका मेडिकल कराया जाएगा. तस्वीरें ये पटियाला जिला कोर्ट की हैं, जहां यहाँ से मैं आपको तस्वीरें दिखाने की कोशिश कर रहा हूं कि किस तरह के बंदोबस्त यहाँ पर किए गए हैं. आप देख सकते हैं नवजोत सिंह सिद्धू पटियाला जिला कोर्ट में पहुंचे हैं. मीडिया को बाहर रोक दिया गया है और ये वैन जो खड़ी हुई दिखाई दे रही है, ऐसा लग रहा है कि शायद जो सुरक्षा व्यवस्था और वाहनों का काफिला था वो यहीं तक है.
हो सकता है किसी तरह की राहत उनको अदालत से मिल जाए, लेकिन फिलहाल सुप्रीम कोर्ट के आदेशों के मुताबिक नवजोत सिंह सिद्धू को पटियाला जेल में भेजा जा रहा है. अदालत में उन्होंने सरेंडर कर दिया है और अब थोड़ी देर में उनका मेडिकल चेकअप के लिए उनको ले जाया जाएगा, जहां से वो सीधा पटियाला जेल में भेज दिए जाएंगे.
सत्यन, और कोई लीगल ऑप्शन सिद्धू के सामने खुला रहता है या उनके ट्वीट के बाद ऐसा लगता है कि वो और कोई लीगल ऑप्शन एक्सप्लोर करना नहीं चाहेंगे?
देखिए, एक तो क्यूरेटिव पिटीशन रास्ता हो सकता है, दूसरा रास्ता अभिषेक मनु सिंघवी ने सुप्रीम कोर्ट में बाकायदा पिटीशन डाल के ये कहा था कि हेल्थ ग्राउंड पर उनको 7 दिन की मोहलत दे दी जाए. और उन्होंने ये भी कहा कोर्ट को कि जो सुप्रीम कोर्ट के आदेश हैं उसके हिसाब से नवजोत सिंह सिद्धू अदालत में सरेंडर करने के लिए तैयार हैं, लेकिन सेहत के लिहाज से हेल्थ ग्राउंड पर उनको 7 दिन की मोहलत दी जाए. हालांकि सुप्रीम कोर्ट ने इसको सुनने से ये कहकर मना कर दिया कि ये अति गंभीर यानी कि वेरी अर्जेंट मैटर नहीं है, लिहाजा रजिस्ट्री के जरिए आप प्रोटोकॉल से आइए. और रजिस्ट्री में वो गए, वहां तक उनकी पूरी सुनवाई नहीं हो पाई, लिहाजा जो सुप्रीम कोर्ट का इससे पहले का ऑर्डर था वो लागू हो रहा है. और उसके तहत सुप्रीम कोर्ट ने बाकायदा पटियाला सेशन कोर्ट और पंजाब एवं हरियाणा हाई कोर्ट को आदेश की कॉपी भेजी थी, जिसकी कार्रवाई शुरू हो चुकी है. नवजोत सिंह सिद्धू ने पटियाला सेशन कोर्ट्स में सरेंडर कर दिया है, जहां से उन्हें पटियाला जेल में भेजा जाएगा.
तो आज रात सिद्धू जेल में बिताएंगे, पटियाला जेल में आज रात बिताएंगे, और इसके अलावा और कोई ऑप्शंस इस समय इनके पास नहीं है. सत्यन,
देखिए, मैं चलता भी रहता हूं और आपको ये बताने और समझाने की कोशिश करता हूं. तस्वीरें दिखाता हूं पटियाला कोर्ट की. देखिए, ऑप्शन नवजोत सिंह सिद्धू के पास हैं कानूनी, लेकिन अभी फिलहाल जो एक विकल्प है वो ये है कि फिलहाल उन्हें सुप्रीम कोर्ट के जिस तरीके से ऑर्डर्स आए हैं उन ऑर्डर्स को फॉलो करते हुए उन्हें कोर्ट में सरेंडर करना होगा और सरेंडर उन्होंने कर दिया है और यहां से उनको पटियाला जेल में भेजा जाएगा। इसके बाद उनके एडवोकेट सुप्रीम कोर्ट में राहत मांगने की अपील लगा सकते हैं, लेकिन फिलहाल उन्हें फौरी तौर पर किसी तरह का रिलीफ नहीं मिला है, लिहाजा उनका ऑप्शन अभी ये है कि वो खुद सरेंडर करते या फिर सरेंडर नहीं करते तो पुलिस उन्हें, पंजाब पुलिस को चूंकि ऑर्डर दिए गए थे, उन्हें गिरफ्तार करके जेल भेजती। लेकिन नवजोत सिंह सिद्धू ने जेल में पुलिस द्वारा गिरफ्तार करके जाने से बेहतर ये समझा कि वो सरेंडर कर दें। और वहां पर भी बाकायदा जब सेशन कोर्ट ने ये पूछा कि 4 बजने वाले हैं, क्या नवजोत सिंह सिद्धू सरेंडर करेंगे या नहीं, तब उनके वकील ने उनको संदेशा भेजा है। नवजोत सिंह सिद्धू यहां पर आए हैं, सरेंडर कर दिया है और अब कोर्ट का प्रोसीडिंग जो है वो शुरू हो गया है।
जी बिल्कुल। इवन एज वी स्टे विद दीस पिक्चर्स ऑफ नवजोत सिंह सिद्धू, सत्येन हमारे व्यूवर्स को इस केस के बारे में बताइए।
देखिए 27 दिसंबर 1988 की बात है। नवजोत सिंह सिद्धू क्रिकेट की दुनिया में पहला कदम रख रहे थे, पहचान उनकी बन चुकी थी और नवजोत सिंह सिद्धू अपने एक दोस्त के साथ बैट खरीदने के लिए पटियाला की मार्केट में गए थे। बैट लेकर पटियाला की मार्केट से जब बाहर निकल रहे थे तो वहां पर नवजोत सिंह सिद्धू की कार खड़ी हुई थी और उस कार को हटाने के लिए गुरनाम सिंह नाम के एक ट्रांसपोर्टर जो कि पटियाला के रहने वाले थे, उनकी उम्र 65 साल थी, उन्होंने कहा था कि गाड़ी हटा लीजिए और उस गाड़ी को हटाने को लेकर यहां पर एक झगड़ा हुआ और उस झगड़े में ये कहा जाता है कि नवजोत सिंह सिद्धू ने गुस्से में आकर हरनाम सिंह के सीने पर मुक्का मार दिया था और मुक्का मारते ही वो नीचे जमीन पर गिर गए थे। लोगों ने मदद करने की कोशिश की और मदद करने के लिए जब लोग उनको ले जाना चाहते थे तो नवजोत सिंह सिद्धू ने उस गाड़ी की चाबी भी निकाल ली थी और जब उनको हॉस्पिटल ले जाया गया तो उनको मृत घोषित कर दिया गया था। परिवार ने यह आरोप लगाया कि ये एक नेचुरल डेथ नहीं है, ये जो हार्ट अटैक भी अगर हुआ है तो इसके लिए नवजोत सिंह सिद्धू दोषी हैं और 304 आईपीसी और 323 का मुकदमा दर्ज कराया गया। 1999 में पटियाला सेशंस कोर्ट ने नवजोत सिंह सिद्धू और उनके साथ उनके दोस्त रुपिंदर सिंह संधू दोनों को बरी कर दिया। पीड़ित पक्ष हाईकोर्ट पहुंचा, हाईकोर्ट में 323 और 304 का मुकदमा शुरू हुआ और यहां पर नवजोत सिंह सिद्धू को 3 साल की सजा सुनाई गई, 1 लाख रुपए जुर्माना लगाया गया। नवजोत सिंह के दोस्त रुपिंदर सिंह संधू को यहां से फ्री कर दिया गया और उसके बाद ये मामला सुप्रीम कोर्ट में गया। सुप्रीम कोर्ट में नवजोत सिंह सिद्धू पर 304 आईपीसी की धारा हटा दी गई, मात्र 323 आईपीसी के तहत उन पर 1000 रुपए का जुर्माना लगाकर उनको छोड़ दिया गया। पीड़ित पक्ष ने फिर सुप्रीम कोर्ट में गुहार लगाई और अब की बार 323 पर कार्रवाई करते हुए 304 गैर इरादतन हत्या अभी भी नहीं लगी है। 323 में नवजोत सिंह सिद्धू को अब 1 साल की कठोर कारावास जिसे कहते हैं उर्दू में बामुशक्कत सजा सुनाई गई है, उनको कैद हुई है। और अब तस्वीरें मैं आपको कोर्ट की दिखा रहा हूं, ये पटियाला जिला कोर्ट है और इस कोर्ट के अंदर डिस्ट्रिक्ट कोर्ट कॉम्प्लेक्स पटियाला आप देख सकते हैं।
आपके पास we have some news just coming in. Let's go straight to that. The Supreme Court has said the dispute should be heard by a district judge. Interim order to stay till maintainability issue is resolved. Want senior district judge to hear the matter. In that sense, this has been transferred. Let interim order continue. The court has said don't want to instruct. District Judiciary Mosque panel says all orders capable of causing mischief. The court has said not casting aspersions on any judicial officer. That's the story we're getting at this side, the Gyanvapi Supreme Court hearing. The latest updates from the Supreme Court, with the court saying the issue of maintainability to be decided on priority. Supreme Court has said senior experienced judicial officer to hear the case. The Supreme Court has transferred the case to the district judge, Varanasi. The civil judge is not going to be hearing the matter. The court has said, the apex court has said, the issue of maintainability will be decided on priority by the district judge in Varanasi. Civil judge is not going to be hearing the matter. The court has also importantly said, our order of the 17th of May is going to continue for 8 weeks. The issue of maintainability is to be decided on priority. the case has been transferred to a district judge. However, the issue of maintainability is going to be decided on priority. The court has said the order of the 17th of May is going to continue for the next 8 weeks. Also, the Supreme Court has said adequate arrangements for Wazoo to be made by the district magistrate. That has to be ensured. The DM to ensure that appropriate arrangements are made for religious observance essentially. So the court is trying to do a balancing act here in terms of asking the district authorities to ensure that arrangements of Wazoo are made essentially for the Muslim side, for those offering prayers at the Gyanvapi Mosque, and the DM also to ensure the same is what the court has said. Arrangements are to be made for religious observance is what the court has directed the district magistrate to do. Meanwhile, the court has also said adequate arrangements for Wazoo should be made by the district magistrate. Very, very importantly, Preeti, the court has said the order of the 17th of May will continue up until 8 weeks. What does this really mean?
Well, it's huge,
Yes.
Sneha, and let's just, break it down for our viewers who are just joining us. What does it mean? And let's quote the learned bench here, and I'm going to quote there. Having regard to the legal issues involved and the sensitivity, we are of the view, the two-judge bench says we are of the view that the civil suit before the civil judge shall now be heard to be tried before a senior and more experienced officer of the UP Higher Judicial Service. This is a huge verdict. The case has been taken away from the Sessions Court. That's the operative part, viewers. And that's the news that we are breaking, Sneha, here. The case has been taken away from the lower Sessions Court. The suit shall now stand transferred from the civil judge who was hearing it. That judge will no longer hear this case. And the reason why, there's also a reasoning given that why the court has transferred the case. The court says, having regard to the legal issues involved and the sensitivity of the case, a more experienced senior officer is needed of the UP Higher Judicial Service to hear the case. Number one is huge, Sneha, that the case now is transferred from the local civil court and gone to a district judge. So that is the big news break. The other big news break, Sneha, is that the area of Wazoo, which was sealed till now, and that has been contested with till now. We've heard the reports that have been filed by Gaurav through the course of the day. Many namazis who are coming there say, "Humko bola gaya tha ghar mein wazoo karke aao." Now the latest, Sneha, that the court is saying is that adequate arrangements will be made of wazoo inside the mosque.
In that sense, Preeti, this is relief for the Muslim side, Nalini, who are extremely unhappy about the Wazoo area being completely sealed. Many of them had been speaking about this. The court has said that arrangements have to be made for this.
Sneha, one thing that the Supreme Court has done from the very beginning, since the first time the matter came up before this court, was to maintain a balance between both sides. They did not want to pass any orders that will be in the favor of one side more in comparison to the other, and they've attempted everything from their end to maintain this balance. And that is essentially why they've said that it will be the order of the 17th of May that was passed by the Supreme Court, which is going to continue to be in operation for the next 8 weeks before this matter is taken up for hearing. What did the 17th May order say in this entire case, Neha? The two main takeaways of the 17th May order was one, that the area where the supposed shivling has been found should be protected and nobody should be allowed to enter that area, so that at a later stage when that issue comes into consideration by the Supreme Court, none of the evidence is damaged. And the second and the more important takeaway from the 17th May order was that nobody should be restrained or stopped from carrying out their religious practices in the premises of the mosque. So today, when apprehension was raised by the Muslim sides, saying that they are not being given a space to perform their wazu, the Supreme Court had asked as to whether or not there are any arrangements made, because that area essentially is sealed, so as to whether or not there are any alternate arrangements made for the Muslims who are visiting the mosque on a daily basis to perform the wazu. And Solicitor General Tushar Mehta, who was appearing on behalf of the government, assured the Supreme Court that alternate arrangements have been made and there will be no problems that will be faced by the Muslim community on a day-to-day basis. So this is the most important concern for the Supreme Court right now, that both the sides feel like justice is being done and that the Supreme Court has taken note of the matter, which is why the order of the 17th of May is going to continue to be in operation for the next 8 weeks. And what the Supreme Court's done is sent the matter back to the district court. They've said that the civil court, which is a lower court in comparison to the district court, is not going to hear the matter. A senior judicial officer in the district court is going to hear the matter. And the issue of maintainability that we have been speaking about since the very beginning needs to be decided on priority. So until the issue of maintainability is decided by the Varanasi district court, the case cannot be heard on merits, which means that first we will hear arguments both from the Muslim side as well as the Hindu side as to whether or not this entire suit and this entire case is even maintainable before the Varanasi court or not.
Nalini, if I may just come in, help decipher this for our viewers. Number one, of course, the Supreme Court will continue to hear the matter after the summer holidays, 1 month of summer holidays where the courts are concerned. But on the issue of the other petitions under the civil court, all of that now stands transferred to a higher officer?
Yes, all of that does stand transferred to a higher officer, Preeti, but at the same time, none of that can be heard until the issue of maintainability is decided, is what the Supreme Court has said. So now, once the matter comes up before a senior judicial officer of the district court, he will now first have to hear the application on Order 7, Rule 11 of the Code of Civil Procedure that deals with the issue of maintainability. And only once an order on maintainability comes by the district court, and if they find that, yes, the matter is indeed maintainable, only then can they go ahead and hear the matter on merits.
One quick point. The Supreme Court has said our order of 17th May, which was, where the shivling, the claimed shivling was there to cordon that off, stands for 8 weeks. What does that mean, legally speaking?
That means that order, which had put no stay on the proceedings before the trial court, if you remember, is the order that is going to continue to be in operation. That is the final order that will stay in operation at least for the next 8 weeks before the Supreme Court takes up the matter for hearing. Because there was a subsequent order that was passed yesterday as well, where the proceedings before the district court had been stayed. But it's not that order that's going to continue to be in operation. It's the order of the 17th May, where the Supreme Court had ordered for the area around the supposed shivling to be protected, as well as ensured that none of the Muslim community people are actually barred from entering the premises of the mosque and are given a chance to go ahead and perform the religious ceremonies inside the mosque. So that is the order that is going to continue to be in operation for the next 8 weeks during the course of the summer vacation until the Supreme Court takes up the matter for hearing again. So essentially, in effect, the matter before the Supreme Court is pending right now. There's going to be no hearing for 8 weeks, but hearings are going to continue before the district court. And in case the Muslim side is not happy with whatever the district court decides on the issue of maintainability, they also have been given the liberty to approach the Allahabad High Court challenging that district court order. So proceedings throughout the course of these 8 weeks before the district court in Varanasi as well as before the Allahabad High Court are definitely expected. And once the Supreme Court reopens after the summer vacation, the matter will come up for hearing once again before the top court.
That's right. We'll try and go across also to both Gaurav and Samarth getting us all those details from Varanasi. But Preeti, in that sense, there is some relief for the Muslim side here, because time and again in court, Advocate MD kept on saying that, there is a pattern to all of this. This is being done to a handful of mosques in the country, and this really isn't the hybrid nature of the country.
Sneha, I think Nalini would also be able to, because legally if you speak, and the way the court has handled it, instead of just relief to the Muslim side, it seems to have walked that tightrope because it's highly sensitive. It involves the matter of faith, though law will take precedence ultimately on the matter of faith. One cannot completely, take away the feelings of a particular community. And now you have one community saying that this is a temple, the other saying this is a mosque.
We'll just come back to you. We have a reaction that is coming in. Let's go straight to that.
तीसरी बात जो
कि ये रिपोर्ट तैयार की गई है और जो जो चीज़ें दिखाई गई हैं उसकी वीडियोग्राफी और फोटोग्राफी हुई है वो दाखिल है। वो अंडर सील है, वो बॉक्स सील कवर में जो चिप है वो वीडियो और फोटोग्राफी की वो सील अंडर सील है, सील में करके 3 बॉक्स में कोर्ट में दाखिल है।
सर अभी जिस तरह से सुप्रीम कोर्ट का जो ऑर्डर है वो डिस्ट्रिक्ट जज को जो केस ट्रांसफर करने के बाद इस पर
अब पहले आदेश आ जाए, आदेश हम लोग भी देख लें कहाँ क्या हुआ है, उसके बाद ही कोई स्थिति क्लियर होगी, उसके बाद ही कुछ कहा जा सकता है। धन्यवाद।
Okay, you heard from the Special Commissioner Vishal Singh, who is waiting a complete order from the Supreme Court. Anisha Mathura also is getting asked more details on that. Anisha was right inside the Supreme Court when the hearing was underway. Anisha, I'm going to come to you for you to break down what the court's order has been. What essentially has the court said and done today in terms of transferring this matter?
Well, let me just break this down to you in the main points. First of all,
questions coming in. Let's go straight to Vishnu Jain, who's responding.
उनका आधार क्या था? क्या प्लेस ऑफ वर्शिप एक्ट?
उनका ये आधार था कि ये सूट प्लेसेस ऑफ वर्शिप एक्ट से बार्ड है। तो माननीय सुप्रीम कोर्ट ने कहा कि वो बार्ड है, ये डिस्ट्रिक्ट जज वाराणसी देखेंगे, उस पर अभी हम कोई कमेंट नहीं करना चाहते हैं। और ये जो SLP है वो भी कंसिडर की जाएंगी। और ये ही 7/11 का मतलब है मेंटेनेबिलिटी ऑफ द सूट का।
उनका आधार क्या था? क्या प्लेस ऑफ
उनका ये आधार था कि ये सूट प्लेसेस ऑफ वर्शिप एक्ट से बार्ड है। तो माननीय सुप्रीम कोर्ट ने कहा कि वो बार्ड है कि नहीं बार्ड है, ये डिस्ट्रिक्ट जज वाराणसी देखेंगे, उस पर अभी हम कोई कमेंट नहीं करना चाहते हैं। और ये जो SLP है पेंडिंग है, ये जुलाई में 2nd वीक में लगेगी।
का समय सुप्रीम कोर्ट ने बोला, इस 8 हफ्ते में क्या होगा वाराणसी में?
नहीं, इस 8 हफ्ते में 1 मिनट देखिए, सुप्रीम कोर्ट ने ये कहा है कि जो उनकी एप्लीकेशन है वो डिसाइड की जाएगी। अब उनकी एप्लीकेशन माननीय डिस्ट्रिक्ट जज साहब डिसाइड करेंगे और जो इंटरिम अरेंजमेंट है वो कंटिन्यू करेगा सुप्रीम कोर्ट के ऑर्डर का 17 मई का, जिससे वो एरिया जहां पे शिवलिंग मिला था वो सील किया गया है।
सेक्शन 3 का जिक्र किया सुप्रीम कोर्ट
जी, सेक्शन 3 का जिक्र, सेक्शन 3 ऑफ प्लेसेस ऑफ वर्शिप एक्ट का जिक्र हुजैफा अहमदी साहब ने किया था, जो मुस्लिम पक्षीय वकील हैं, और उनका कहना था कि किसी भी प्लेस ऑफ वर्शिप को बदला नहीं जा सकता है। उस पर सुप्रीम कोर्ट ने ये कहा कि धार्मिक, उस पर ये कोर्ट की टिप्पणी है। मैं सिर्फ आपको सिर्फ बता रहा हूँ, मैं ये नहीं कह रहा हूँ कोर्ट ने ऑर्डर पास किया, ये सिर्फ एक डायलॉग हुआ है 2 लोगों के बीच में। तो उस पर कोर्ट ने ये कहा है कि धार्मिक स्वरूप भी जो है वो भी डिटरमाइन करना जरूरी होता है, जो हमारा पक्ष है। तो ये सारी चीजें डिस्ट्रिक्ट जज वाराणसी करेंगे। मुझे लगता है मैंने आप
What all exactly will the Varanasi court be hearing on? What all will it be
Varanasi court is now free to decide their 7/11. Supreme Court has said that it will be decided on priority. So 7/11 में जो कंसेप्ट्स हैं धार्मिक स्वरूप के, जितनी भी चीजें हैं वो 7/11 के कंटेंट में आएंगी। वो हम भी वहाँ पे आर्ग्यू करेंगे, वो भी आर्ग्यू करेंगे। वी आर वेरी हैप्पी विद द ऑर्डर।
वो सारी चीजें
हम बहुत संतुष्ट हैं एंड वी आर वेरी हैप्पी विद द ऑर्डर।
We are very satisfied with what the court has said, is what the Hindu side essentially is saying. The lawyer, the Hindu side, speaking to the press. Then I'm going to go back to Anisha, who continues to be with us from the court. Anisha, break this down for the benefit of our viewers who've just joined us. What does the court order really say today?
Well, as I was saying, the Supreme Court order is on the main issue, that the issue of whether these petitions, the petitions filed by the Hindu side, are maintainable or not, that has to be heard on priority. And this entire petition, with regard to all the petitions that have been filed, that was everything that was being heard by the civil judge, will now be heard by the district judge of Varanasi. The court has said that we want that a seasoned, experienced judicial officer, a senior officer, should hear these matters, because there are a lot of legal nuances, and this is a matter of great public importance as well. The court has also, the second thing that the court has said, that the 17th May order that was passed by the Supreme Court, where it had said 2 things. One, that if there is a shivling that has been found, that whatever has been found must be protected. And 2, that there should be no obstruction whatsoever to the observances of the namaz or any other rituals that are being followed there. So for both the shivling and the namaz, namaz, the protection to continue, the district magistrate to ensure that arrangements are made for the wazu before the namaz, and the district judge Varanasi to now hear all of these matters. What is going to be seen as a win for the Muslim side is that the issue of maintainability of these petitions has to be heard on priority. However, at the same time, the Hindu side can also claim a win because the Supreme Court has questioned that we say that the determination of what is the religious character of a place, is that determination barred by the Places of Worship Act. However, the court has said we are not making any comments on this. This is a question, this is only a matter of discussion. So this legal question, the court has made it clear where it is likely to go with the legal questions involved in this matter. For one, the district judge to hear whether to hear all these petitions, the civil judge will no longer hear it. All of these issues will now have to be worked out in the district judge court, and the Supreme Court will hear these matters once again in the second week of July, as it is now breaking for summer vacation. But an indication has been given from the Supreme Court on where are the legal nuances that it could consider later. That does the Places of Worship Act say that if there is a question mark over the religious character of a place, then is that also barred from any inquiry? But if that kind of an inquiry is allowed, what will that mean as a larger question, particularly since Huzaifa Ahmadi, the lawyer for the Muslim side, has pointed out that this is not the only point. Across India, there are multiple sites where there are different timelines of temples. There are different kinds of Hindu temples, Buddhist temples, Muslim mosques and other areas which coexist in the same site. In fact, Justice D.Y. Chandrachud, while discussing this, had given an example that if there is a place where a Parsi Agyari and a Christian cross exist in the same premises, is that a Christian church or is that a Parsi Agyari? Can you really say anything about the character of that place? But that is a question that the court will have to consider at a later stage. For now, the gist of today's hearing has been that the district judge Varanasi and not the civil judge Varanasi will hear this matter further, and the issue of whether the petitions are maintainable or not is the first priority for the district judge to handle. In the meantime, there will be no change on the ground as such. The shivling area will remain sealed, but there will be no obstruction to namaz. It is for the administration to ensure that arrangements are made for the wazu. Back to you.
Yes, Anisha. In fact, I'm also going to go across to Preeti, who's with us in the studio today. But Preeti, in fact, has been at the Gyanvapi Mosque. Preeti, today the court has also said an important thing about the right to worship and the fact that, the Muslim side did say that we're unhappy about obstruction when it comes to using the wazu khana, essentially. The court has said that is something that has to be ensured by the administration. Just tell us a little more, Preeti, about the sentiments involved since you were at the mosque about the need to, in fact, perform wazu at the wazu khana within the premises of the Gyanvapi Mosque.
We'll pull in Anisha also in this conversation, Sneha, because what changed? What changed was from the Allahabad hearing to the Supreme Court hearing was that the wazu khana area was cordoned off or was sealed. That was a contention which the Muslim side took to the Supreme Court, saying that, listen, this is interfering with our right to pray, therefore the 1991 Places of Worship Act. And Anisha, I'll bring you in on this because the Supreme Court today has primarily stated, Anisha, that the area of wazu will take place. There will be now a wazu khana there. Till now, the namazis were not able to use the wazu khana. What happens now? Is the DM now entrusted with the condition of making sure that a wazu khana is created?
Well, Preeti, let me put it this way. The Supreme Court has said that since we don't know what exists where, we are leaving it to the district administration to make sure that whatever was found that is being called a shivling, that part is protected, but at the same time, proper arrangements for wazu before namaz are made. So it is now basically, instead of passing an order, the Supreme Court has left it for the district administration to ensure that both religions can coexist in that small space. Now, you've been at this spot, you've seen the way this entire thing is structured. featured, Senior Advocate Huzaifa Ahmadi in his arguments had attempted to say that since there is iron railings and locks being put around that fountain area, the namazis who are trying to go and give namaz, they can't even access the taps that are there around that fountain. Now, but on the other side, Solicitor General Tushar Mehta said that if we allow those taps and to be opened and the area to get accessed, there could be a law and order situation. The Supreme Court has very clearly said that we are not passing any orders outside of what we've already said. We have said on the 17th of May that there should be no obstruction to wazu, there should be no obstruction to the namaz. So it is for the district administration to ensure that proper arrangements are in place. The shape that will take on the ground is something we'll have to see. Whatever arrangement was made today, for example, and that is me giving you an example, whatever arrangement was made today to ensure that the namazis were able to do wazu, the district administration will have to ensure some kind of arrangements are made, even if they are claiming through the Solicitor General.
Well, today there was a fair amount of confusion, but Anisha, Sneha and I want to just ask you one very quick question. If you look at it and you break it down on what the order the Supreme Court passed today is the most operative part of the order. Of course, the Supreme Court did not say it, but the sheer fact that the Supreme Court has transferred the case to a district judge from a civil judge, does the Supreme Court is giving the indication that a more senior, experienced judicial officer now needs to hear the case, and that possibly they were not quite happy with the junior civil judge hearing the case?
Well, Preeti, to answer that question, the court has in its order and in its observations both said two things. That A, we want that a more senior experienced judge should hear this case, which is why we want to send it to the district judge, who is of course a senior officer of the district higher judiciary, who has at least 20 to 25 years of experience behind him. But at the same time, they said that we are not making any aspersions as far as the conduct of the civil judge is concerned. So for the last several days, the kind of issues that we've seen, that the allegation, the argument of the Muslim side that the civil judge acted incorrectly, those arguments the court has not said anything about. They have said very clearly, we are sending it to a more experienced person, but that does not mean that we believe that there was something wrong with the civil judge. It is only that we want that a more experienced person should see this. So at the same time, as I said, the court is trying to play a very, very fine balancing act.
It's a fine balancing act. You're very right, because, there is, it's a matter of faith, even though law will, take over faith in this situation. But there is a lot of people's emotions that are involved, and the court has completely walked that tightrope line on this. But I want to bring you in, Anisha, and I want to ask you. Now, we know the Supreme Court is going to continue to hear the matters from the 15th of July after the summer vacation break. When does the district judge now start hearing the matter?
Well, there is no date given. Preeti, as of this moment, as of the moment of pronouncement of this order, the files will have to be transferred from the office of the civil judge, Varanasi, to the office of the district judge. And they should, ideally, it does not take more than 1 or 2 days maximum to transfer the files, to transfer all the documents. So we should see something happening. We should find out in the next day or two when the hearing will be in the district judge's court. Now, today, especially being Friday, there is a weekend involved, and there is also from Monday or Tuesday, the next couple of days, we should find out when the hearing will happen. But there is no timeline as such for the transfer. The court, what the court has said here is that our order of the 17th of May will continue for the next 8 weeks, which basically means that till the time, that seems to be sort of a guideline of sorts, so that the district judge can hear the matter, can make some sort of a decision, while the Supreme Court's order of status quo on the ground is still in force. So we are expecting that in the next few days this matter should be heard before the district judge, particularly since the court has said that the maintainability issue will be the priority. The court has said that we will take up this issue again in July. So during the time when the Supreme Court is on its summer vacation and the district courts are still functioning, we should see some movement in this case.
Yes, for sake of clarity, Anisha, also explain explain to us what the court essentially has said about the 17th of May order, its own order, and how that has to be maintained?
Well, the 17th of May order, if I may remind you, on the 16th of May, there was which was a Monday, which was a holiday in the Supreme Court, there was a survey going on in the disputed area. Now, on that date, the Hindu petitioners went to the civil court Varanasi and said that we believe that a shivling has been found where the Muslim side believes that there is a fountain. On the basis of that claim by the Hindu side, the civil judge Varanasi had passed a direction that you seal off that entire area, you restrict entry of persons into the entire area to just 20 persons who can offer namaz, and because of that, the Supreme Court then passed its 17th May order, which is now what is going to stay in operation, where the Supreme Court said two things. One, that there will be no restriction on entry of persons who want to enter the mosque and offer namaz. You will have no obstructions whatsoever to the namaz being offered or to the rituals that are done before the namaz is offered. Secondly, what the court had said, that if there is a shivling or whatever it is that has been found that is being claimed to be a shivling, you must protect that, because the Hindu side had expressed the apprehension that some damage to that structure could happen if people are allowed to go near it. So after that, the Supreme Court passed an order that you protect what is there, what is the shivling, and you protect the namaz both, and it is for the district administration to ensure that both things are carried out simultaneously, that the namaz is also carried out properly without any obstruction, that there are arrangements made for the wazu, and what is being said to be a shivling is also protected. Now, we've seen over the last 3-4 days that iron railings have been put around that structure which the Hindu side believes is a shivling, and locks have been put in to make sure that nobody can go in. In addition, there were the pipelines that were there that were sending water into that area have also been stopped, so that there is no water damage to that place. So all of that will continue, but the court has said that you must make sure that alternate arrangements for wazu are also put in place.
Today, of course, we saw, Anisha, the Muslim side arguing that the maintainability of the suit should be heard on priority. For the sake of clarity, explain to us, what does the maintainability of the suit in this case really mean?
Okay, legally, maintainability of a suit means that can something that is being asked for by the petitioner, can the court even hear this matter, and can the court pass any orders in that matter? That is where the main that is where the main argument of the Muslim side lies. They have said that the right to worship petitions cannot be heard by the civil suit, because any hearing on the right to worship petition will have a direct bearing on the religious character of the place of worship, which is barred by the Places of Worship Act. To put it in simpler terms, the Muslim side has said that if you go into the question of whether there can be access or whether there can be any modification to either the Shringar Gauri temple or the area where the shivling is being said to have been found, then what you're doing is violating our right to have the namaz there. You're violating the existing mosque in that particular area, and under the Places of Worship Act, whatever existed at the time of independence has to be allowed to exist. So because the mosque has been there for more than 350 years, you cannot now say that there should be some change in that entire premises so that the Hindu petitioners can access the Shringar Gauri Mandir or the other idols which are there in that place. The maintainability issue essentially comes down to this. Can the court say that because X's right to worship exists, then Y's right to worship can be changed or modified? And the Muslim petitioners are saying you cannot do that, because the Places of Worship Act bars you from hearing any petition which seeks the alteration of the religious character of the place. And that is where this entire issue really lies, and that is where the court has said that the district judge should hear the question of maintainability before anything else can happen, because the Muslim side is saying that the moment you say that a survey should be conducted, the moment you say that any sealing can be conducted or any modification can be conducted, you are in fact changing the religious character of the area, and that is something that you cannot do. This petition is simply not maintainable. The Hindu side, of course, says that no, we are not changing the religious structure. The religious structure, the religious character of this area is of a temple and not of a mosque. So if our petition is allowed, there is no change. We simply get back what we should have had all through. So now that where the entire controversy will lie, and the maintainability issue will now have to be considered by the district judge on whether the right to worship of ex-devotee can at the same time exist with the right to worship of Y devotee. Back to you.
You know, Anisha, appreciate it. And thank you for breaking it down in terms of what maintainability means, because that's going to be pretty much the fulcrum on which this entire case stands on. But I want to ask you now, because for the benefit of our viewers who are wondering, while the Supreme Court is on vacation, if the district court, now the lower court, actually rules on maintainability, what happens then once the Supreme Court reconvenes and starts hearing the case from the 15th of July?
Well, Preeti, if this district judge actually, this is quite a big if, because this is going to be a long, very lengthy argument. If the district judge believes that the suits are maintainable, then the hearing in the suits could begin. More importantly, whichever side loses the argument, if the court says that yes, this is maintainable, it is open for the Muslim side to challenge that order in the High Court, and if they lose in the High Court as well, then again in the Supreme Court. If the Hindu side loses and the court says no, you cannot file these petitions are not maintainable, the same route is open to them as well. You can challenge the order before the High Court, and then if you lose in the High Court, you come to the Supreme Court. Effectively, what the Supreme Court has done is said that, well, you should have sorted these issues out in the lower court. But since you've come to us, what we are saying is that instead of us taking this over, why don't you let the initial issue be decided by the civil court, and then the normal route, the normal steps of justice, so to speak, are always open to you. Back to you.
All right, Anisha, thank you for joining us, but I'm going to hold on to you because all eyes right now on this particular order that the Supreme Court has passed. So somebody who was in court while this order was being passed, would you give us the big takeaways? What has been the biggest takeaway that has come from the Supreme Court on the Gyanvapi Mosque order?
Well, there are 3 or 4 big takeaways here, Preeti. One, that the petition, the suit is transferred to the district judge, which means that the civil judge will no longer hear this case. It will be the district judge, who is a senior responsible officer. Secondly, the 17th May order, which basically means that the district administration now must protect both the shivling and the namaz at the same time, and ensure that the arrangements for wazu and other rituals is also made. Thirdly, what the court has said is that we will continue hearing your objections, your case in July, that is after the summer vacations, and till that time our 17th May order will continue to remain operational. So these are the basic points that we come away with. One big indication of where this could possibly go that the court has given, but this is part of the discussion and not the order, is that the court has questioned that does the Places of Worship Act stop anyone from trying to find out what is actually the religious character of a place, particularly of a place where multiple religions, symbols or multiple religious observances exist. But there again, the Muslim side has pointed out that if we allow this kind of determination to happen, if we allow anybody to challenge and question what is the actual reality of XYZ place, then India has a lot of places where temples from different historical eras, temples from Hindu, Buddhist and Jain religions, or temples and mosques or temples and churches exist in the same area. So that if you open that to debate, that will create that will have a much larger impact across the country. So that is, however, the court has questioned whether that is something that can be considered at all. Back to you.
So that window of opportunity to discuss this entire issue and a larger debate on that is something, Nalini, that you would say is expected, given that the court has asked this question today?
Well, definitely, Sneha, that's bound to happen no matter what, because irrespective of which way the district court will now rule on the issue of maintainability, whether or not they decide that this case is maintainable or they decide that the case is not maintainable, either way, an appeal is going to eventually be filed before the Allahabad High Court. And the same thing is going to be repeated before the Allahabad High Court once again. If the Allahabad High Court decides that this entire case is in fact maintainable, then the Muslim side is going to approach the Supreme Court in an appeal. And if it happens the other way around, then the Hindu side is going to approach the Supreme Court in appeal. So the matter is eventually going to come back to the Supreme Court. There is no doubt about that. And it will be the Supreme Court that will finally rule not only on the issue of maintainability, but definitely also on the issue of merits. But at the same time, for the Supreme Court to have the assistance of the opinion that has been given by the district court and then again by the High Court will help them massively in fast-tracking these proceedings once they do approach the Supreme Court. Because a lot of issues of laws the Supreme Court will not have to delve into, because they might have already been pre-decided by the High Court or the District Court earlier. So that is essentially why the matter has been sent back to the District Court to be decided by a senior judicial officer, and the liberty has also been given to the parties to approach the High Court in appeal in case they are not happy with the decision of the District Court. But for the next 8 weeks at least, the proceedings are expected to go on only in UP and not before the Supreme Court. And once the Supreme Court reopens after vacations, we'll have to see exactly what stage the proceedings in the district court are and as to whether or not the Supreme Court will take it up further for hearing.
Well, absolutely. Nalini, for our viewers, do give us an idea about the current case and also to tell us a little more about the manner in which the Gyanvapi Mosque has not for the first time been in a controversy. This is an old case. In fact, this all started in the year 1991.
Well, it's very interesting because of the number of years that have been passed since the time that this issue is being debated. The Places of Worship Act right now, Sneha, is actually being used by both sides for their benefit. Because essentially, what the Places of Worship Act says is that the religious character of a place of worship should not be changed, and it should remain as it was on 15th August 1947. And this is being exploited by both sides for their benefit, where the Muslims on one side are claiming that because the religious character of the place should not change, it should remain a mosque. But the Hindu side is claiming that the original religious character of those premises was that of a temple. And because the religious character was changed in the first place is why a structure that they are now calling a mosque was allowed to be constructed there in the first place. So it becomes a very precarious situation for the Supreme Court to decide on this issue until unless they have more evidence from the ground on what exactly the findings of this report are. Now, these reports have not been filed before the Supreme Court. These reports have only been filed before the District Court, and the Supreme Court, rightly enough, has not even called for these reports because they have clearly said that the District Court does have the wisdom to decide on these reports that have been filed by the Commission. So it remains to be seen exactly what is going to be the takeaway of the District Court when these reports are actually taken up for consideration. And now that the Supreme Court's given the green flag for the proceedings before the District Court to continue after a brief stay that was put in place yesterday, in the next hearing, we can very well expect for both these reports to be taken up for consideration by a senior judicial officer of the District Court. And that is exactly what will form the crux of this entire matter. But before any arguments can happen on that front, One thing that the Supreme Court's made very clear is that first the district court will have to decide on the issue of maintainability. So until or unless the district court decides whether or not they have the jurisdiction to hear the case, and the Muslim side will of course be arguing that there is no jurisdiction in the matter and that the matter should be transferred to either a higher court or to a court in a different jurisdiction. And the Hindu side, of course, is going to be pushing for the Varanasi court to continue hearing this. But however the Varanasi courts decide, only after that can they take up this report for official consideration and see what the contents of this report actually reveal.
Be with us. We'll just come back to you, Nalini and Isha. Also, Preeti, continue to be with us. In fact, we have a series of reactions that have come in after what the court said today. Listen in.
देखिए, सुप्रीम कोर्ट ने इस मैटर का ट्रायल डिस्ट्रिक्ट जज के सामने ट्रांसफर कर दिया, डिस्ट्रिक्ट जज वाराणसी के सामने। दूसरी बात, जो सुप्रीम कोर्ट का इंटरिम अरेंजमेंट था 16 मई का, वो होगा। तीसरी बात, जो उनका वजू के लिए वो अरेंजमेंट मांग रहे थे, कोर्ट ने कहा उसके लिए अरेंजमेंट किया जाए। पर जो 16 मई का ऑर्डर है सुप्रीम कोर्ट का उस एरिया को सील करने का, वो बरकरार रहेगा। 16 मई, हाँ, 17 मई का ऑर्डर बरकरार रहेगा। जो मुस्लिम पक्ष की एप्लीकेशन है 7/11 की, वो भी प्रायोरिटी पे डिसाइड होगी। ये चार बातें मुख्यतः सुप्रीम कोर्ट ने आज कही हैं, और ये भी बात कही है कि जो हमारी एडवोकेट कमीशन की रिपोर्ट है वो भी उसको कंसिडर करने में कोई रोक नहीं है। उनकी एप्लीकेशन प्रायोरिटी पे डिसाइड होगी, पर बाकी चीजें भी इस समय डिस्ट्रिक्ट जज के सामने खुली हुई हैं, वो कैसे प्रोसीड करना चाहते हैं। ये माननीय डिस्ट्रिक्ट जज वाराणसी का अब प्रेरोगेटिव।
अब जो माननीय सर्वोच्च न्यायालय का आदेश है वो मान्य होगा, जो देखा जाएगा उसको। जो एपेक्स कोर्ट ने जो आदेश दिया है वो उचित व जायज है। 10:15 में चूंकि सब मैंने रिपोर्ट ये सबमिट कर दी थी, उसके बाद माननीय सिविल जज कोर्ट में ये दाखिल था। उसके बाद अगर कुछ हुआ वो तो जानकारी नहीं, अभी उसके पहले तक कोई लीक नहीं हुआ था।
All right, let's now shift back to our reporters. Nalini, who's breaking the judgment down, Anisha, who's been in court tracking the case in Supreme Court. I want to bring both the ladies back into this conversation. Anisha, you know, what's interesting here is because it'll also have a lot of unsaid implications. As we speak, there is a petition in a Mathura court right now on the maintainability of the plea, which says that the mosque needs to be removed from the Krishna Janambhumi. Will there be any implications there?
Well, Preeti, directly, no. Directly, there will be no implication whatsoever of the Supreme Court's order that has been passed today, because remember, the Supreme Court has been very, very careful to not say anything whatsoever about the merits.
We have some news just coming in. Pictures of Navjot Singh Sidhu surrendering at the Patiala court. These are pictures of Sidhu right now at the Patiala court, from where he's going to be taken to jail. Remember, Navjot Singh Sidhu has been convicted. Quantum of punishment announced by the Supreme Court yesterday. 1 year of rigorous imprisonment in a road rage case, which is in fact as old as 34 years. This incident had taken place in the year 1988 when Navjot Singh Sidhu was involved in a road rage incident. He had beaten up a man, and that man had died even before he reached hospital. Navjot Singh Sidhu has been in fact convicted by the court, and the quantum of punishment has been announced as well. Sidhu was to surrender before the Patiala court today. He's done that. He's now going to be taken to jail after a detailed medical checkup is done. That exactly is the procedure. What the legal options are for Navjot Singh Sidhu? Can he expect some relief from the court? That is something that we have to wait and watch. But for now, there is trouble for Sidhu. Tonight is going to be the night in jail for Navjot Singh Sidhu, former president of the Congress Party, of the Punjab unit of the Congress Party. Pictures of Navjot Singh Sidhu from earlier today, where he was leaving his residence to move to Patiala court, where he surrendered, as had been ordered by the Supreme Court. A detailed medical checkup, and Sidhu is going to be spending the night in jail. 1 year of rigorous imprisonment is what the Supreme Court has announced. Remember, Navjot Singh Sidhu was asking for more time to surrender on health grounds, a plea that the court did not entertain. We'll try and go across to Satyen for more on that, on what could be the possible legal options for Navjot Singh Sidhu. Right now, it does appear that tonight Navjot Singh Sidhu will be spending in jail. This is the case of the year 1988. It was a road rage case involving Navjot Singh Sidhu, in which he had beaten up a man who had died later at a hospital. Even before reaching hospital, in fact, he had died. And this case has been lingering for 34 long years now. Sidhu has been convicted, rigorous imprisonment of 1 year. Tonight is going to be his first night in jail after being convicted and after the quantum of punishment being announced by the court yesterday. With that report, it's time for a quick break here. Our non-stop focused coverage on the Gyanvapi Mosque and what the Supreme Court has said today vis-a-vis what should be done by the district magistrate to ensure that rights of all is protected. We're getting you all the details on the other side.
You are watching India Today.
After 2 years of paralyzing pandemic, the world is ready to bounce back. Will shifting power centers make this India's big moment? Risk, resilience and revival on the agenda. What's India's role in the global rebalance? India's top world watcher takes you to the front lines of the global high table with top minds from politics and business for the biggest global brainstorm. Live and exclusive coverage only on India Today TV.
You are watching slow.
Make your media plan smarter with India Today Live TV on your connected devices.
You are watching
Make your media plan smarter with India Today Live TV on your connected devices.
You are watching India Today.
Volta's Pure Air Adjustable AC.
Good evening, viewers. You're watching 5 p.m. live. I'm Preeti Chaudhary. Our top focus is the order that has come in from the Supreme Court on the Gyanvapi row. Viewers, the Supreme Court has now transferred the case from a Varanasi civil judge to a higher district judge. The Supreme Court wants a more experienced judge to hear the case. No way are they casting aspersions on the junior judge, but they say that a more senior judge needs to hear this case. Somebody who has about 25 years behind him, because the case is extremely sensitive and understandably so, viewers. It's got the nation's imagination. We're going to get you all aspects of what went down in Supreme Court today. Let me take you through the headlines. Supreme Court transfers Gyanvapi case to the District Court. Muslim side's plea challenging maintainability of the suit to be heard on priority. 17th May order protecting shivling will continue. India Today news break on language war explodes as Prime Minister Modi wades into controversy, says all languages are equal.
भाजपा भारतीय भाषाओं को भारतीयता की आत्मा मानती है और राष्ट्र के बेहतर भविष्य की कड़ी मानती है.
Kannada superstar Kicha Sudeep speaks to India Today, hails Prime Minister Modi's unifying message, says country must embrace all languages. After the Supreme Court shot down plea, former Punjab Congress chief Navjot Singh Sidhu surrenders in Patiala court. CBI raids at 17 locations against RJD Supremo Lalu Yadav, wife Rabri and daughter Misa Bharti over corruption charges in a land for jobs scam. Big development in Supreme Court that's transferred the Gyanvapi case to a district judge. The Varanasi district judge will now be hearing the case, meaning in the second week of July is when the Supreme Court will hear the case. 17th May order of the Supreme Court of ensuring that religious rituals of the mosque and the reported shivling are protected to continue till the next hearing. Issue of maintainability of the case to be decided on priority. Meanwhile, devotees gathered outside the mosque to offer Friday prayers. The Masjid committee has appealed to the people to come to the mosque in small numbers due to the sealing of the Wazukhana. Now, the court also gave a very big order where it says that the district administration is now responsible to make sure that wuzu takes place at the premises of the Gyanvapi Mosque. This morning, viewers, our reporters have been tracking the Gyanvapi Mosque namazis. Many of them said that they were told to wuzu at home and come and offer namaz there. However, the Muslim sides are now saying that all the claims made by the Hindu side are incorrect and that there was never a temple. But all of that aside, the Supreme Court today has walked that very thin line, viewers, of balance. It's delivered a very, very balanced order. The Supreme Court will hear what goes down in terms of the case from the 15th of July once it reconvenes after the summer vacations. The district court that has been transferred the case from a civil court in Varanasi will continue to hear the petition of the civil court through the course of the next 1 month, but they will have to begin with the moot question on the maintainability of the plea.
अब जो माननीय सर्वोच्च न्यायालय का आदेश है वो मान्य होगा, जो देखा जाएगा उसको, जो एपेक्स कोर्ट ने जो आदेश दिया है वो उचित व जायज है। 10:15 में चूंकि सब मैंने रिपोर्ट ये सबमिट कर दी थी, उसके बाद माननीय सिविल जज कोर्ट में ये दाखिल था। उसके बाद अगर कुछ हुआ हो तो जानकारी नहीं, अभी उसके पहले तक कोई लीक नहीं हुआ था।
देखिए, सुप्रीम कोर्ट ने इस मैटर का ट्रायल डिस्ट्रिक्ट जज के सामने ट्रांसफर कर दिया, डिस्ट्रिक्ट जज वाराणसी के सामने। दूसरी बात, जो सुप्रीम कोर्ट का इंटरिम अरेंजमेंट था 16 मई का, वो होगा। तीसरी बात, जो उनका वजू के लिए वो अरेंजमेंट मांग रहे थे, कोर्ट ने कहा उसके लिए अरेंजमेंट किया जाए। पर जो 16 मई का ऑर्डर है सुप्रीम कोर्ट का उस एरिया को सील करने का, वो बरकरार रहेगा। 16 मई, हाँ सॉरी 17 मई का ऑर्डर बरकरार रहेगा। जो मुस्लिम पक्ष की एप्लीकेशन है 7/11 की, वो भी प्रायोरिटी पे डिसाइड होगी। ये 4 बातें मुख्यतः सुप्रीम कोर्ट ने आज कही हैं। और ये भी बात कही है कि जो हमारी एडवोकेट कमीशन की रिपोर्ट है वो भी उसको कंसिडर करने में कोई रोक नहीं है। उनकी एप्लीकेशन प्रायोरिटी पे डिसाइड होगी, पर बाकी चीजें भी इस समय डिस्ट्रिक्ट जज के सामने खुली हुई हैं, वो कैसे प्रोसीड करना चाहते हैं ये माननीय डिस्ट्रिक्ट जज वाराणसी का अब प्रेरोगेटिव। 7/11 की एप्लीकेशन होती है, जो मुस्लिम पक्ष का ये कहना था कि जो हमने सूट फाइल किया है वो मेंटेनेबल नहीं है, वो सूट चल नहीं सकता है। उसके लिए उन्होंने 7/11 की एप्लीकेशन डाली थी, मतलब इसको इमीडिएटली रिजेक्ट किया जाए। तो कोर्ट ने कहा है कि डिस्ट्रिक्ट जज वाराणसी उसको कंसिडर करेगा और जो बाकी चीजें हैं वो भी कंसिडर की जाएंगी। और ये ही 7/11 का मतलब है मेंटेनेबिलिटी ऑफ द सूट का।
उनका आधार क्या था? क्या प्लेस ऑफ
उनका ये आधार था कि ये सूट प्लेसेस ऑफ वर्शिप एक्ट से बार्ड है। तो माननीय सुप्रीम कोर्ट ने कहा कि वो बार्ड है कि नहीं बार्ड है, ये डिस्ट्रिक्ट जज वाराणसी देखेंगे, उस पर अभी हम कोई कमेंट नहीं करना चाहते हैं। और ये जो SLP है पेंडिंग है, ये जुलाई में 2nd वीक में लगेगी।
All right, viewers, the big takeaways once again would like to clarify that the Supreme Court will start hearing the matter in the 2nd week of July once it reconvenes after the summer vacation, not on the 15th of July, in the 2nd week of July. However, the district court where the matter has now been transferred to will start hearing the matter once all that paperwork is handed over from the civil court to the higher court. I want to quickly take you through the big takeaways today, viewers. What has been the biggest takeaways of the Supreme Court order? Number 1, the district judge will now hear the civil suit. The civil judge will no longer continue hearing the petition. The Supreme Court has said that the matter needs to be handed over to a more experienced judge, having casting no aspersions to the lower judge, saying there's nothing wrong with what went down, but now the matter will be heard by a more experienced judge. Number 2, the Muslim side's plea on maintainability. This is crucial. Of case to be heard on priority basis. The district court now, viewers, before it takes up any petitions, before it takes up the Mashringor Gauri petition, before it takes up anything, it will take up the issue of maintainability. What is maintainability? We're going to get you a larger breakdown right after that with my colleague Anisha. The third big takeaway, the Supreme Court has ordered the protection of the shivling to continue, and this order will stand for 8 weeks starting from today. The fourth big order today, the DM, the district magistrate and the local administration will ensure arrangements be made for namaz and wazu. Till now, wazu was not taking place in the area, but now the Supreme Court has said wazu will take place. It's the responsibility of the DM. And lastly, the Places of Worship Act 1991 remains where it is. We're going to cut across to our reporters, get you a larger understanding on the biggest takeaways of the Supreme Court order. Anisha, other than the fact that now the case will be transferred from a civil judge to a district judge, the court will hear the matter, the Supreme Court will hear the matter, second week of July, the district court will start hearing it as and when the files are transferred. The biggest question comes on the district court. The first matter they will deal with is maintainability. Explain to our viewers.
Well, Preeti, maintainability of a suit basically means that whether or not the court can hear the matter at all, whether the pleas that have been filed, the prayers that have been asked for in the petition are legally valid or not. Now, the Muslim side in their application, the 711 application that there was such a long discussion about, they have said that the suit filed by these 5 women petitioners is not maintainable at all, that you cannot claim a right to worship because that right to worship will substantially modify the religious character of that entire premises. Now, what the Muslim side is saying, that by even asking for a survey of the area or asking for sealing of any part of the area or asking for change in the way you can access certain parts of that area, you are substantially altering the religious character of the premises, which is something that is completely prohibited under the 1991 Places of Worship Act. Now, that is the point where this Muslim side has made. On the other side, of course, the Hindu petitioners have claimed that there is no modification beg your pardon, of the places of the religious character of this entire area, because what we want to say is that there was already a temple and all we want is right to access the temple on every day instead of being restricted to 1 or 2 days in the year. What we also want is that since there are more idols, that there are more religious symbols inside that premises that you call the Gyanvapi Mosque, let us as the Hindu petitioners go inside and worship those idols, because according to us, though that is the original old temple premises. Now, the district judge will have to hear this matter. Can there be any kind of right to worship petition filed in a case like this, where the title, where what is on that land is not before the court? So that is the basic point of maintainability. Can the court hear these matters at all, or is the prayer being asked for by the women, Hindu women petitioners, is that completely barred? Back to you.
Stay with me, Anisha. I'm going to cut across right now to Abhishek Mishra, because what happened right now in the national capital at the Apex Court has resonated all the way in Mathura, at the Kashi Vishwanath temple, at the Gyanvapi Mosque, and the citizens of Varanasi as well. Abhishek Mishra, take us through how the Supreme Court order has been taken by both sides of the divide, be it the Hindu side or the Muslim side.
Well, absolutely, Preeti. Both the sides have now accepted the fact that whatever order has been given, they have to follow it. And at the same time, we have seen also when earlier when this petition was filed, the Muslim side was very keen on having a say on this survey to rest the situation as it is. But for now, the Supreme Court has instructed to, as far as the maintainability is concerned, the wazu should be protected. At the same time, there has to be arrangement made separately. So that is one thing. On the other hand, it is very important that the Muslim side please challenging the maintainability of the suit to be heard on priority. This is what has been said. And also, by transferring it to the district court, this is very important that the court has felt the need of some more experience as far as this issue is concerned, and that is the only reason this has been said. So both the sides so far are now not saying much. The Hindu side has already spoken about it, and Muslim side, who was always keen about this whole survey has been referring it as a violation of the Religious Space Act is now is a kind of relief for them, because now this particular case will be heard by the district court, by the district judge. So that is one thing. But yes, indeed, one by one, we have been witnessing here that this whole issue, be at the survey from the start, and then the protest coming there, then the the 3-day survey again happening, the change of the court commissioner, then that important report being filed in the court, and now Supreme Court giving their standing is a clear indication that this issue is gonna take more moment now. And as far as both the sides are concerned, they all are on their stand as far as the survey, and then of course the maintainability of the situation is concerned. Yes,
it's been a tightrope walk. There's been a clear amount of balance. I want to bring in Anisha back into what the Supreme Court order said today. What could be its implications? You know, Anisha, it's if the order copy, I'm sure, is yet to be uploaded. But with what you heard today, it's not a win for any side, really. It's a very, very balanced order, keeping in mind the sensitivities involved, keeping in mind the entire communal, divide, which was getting only wider through the course of this trial.
Well, yes, Preeti, you've hit the nail on its head. The Supreme Court has very clearly tried to create a very, very thin balance between the expectations and demands of both sides, as well as the reality on the ground. The Supreme Court has effectively said three things. One, the district judge will hear the matter, not the junior civil judge. Two, that the issue of maintainability of the petition will be heard first, and the larger implication of that order, Preeti, is that if the district court passes its order one way or another with regard to the maintainability of the petition, then that also will have an impact on whether the survey report will be taken up or not, or when it will be taken up, if it is taken up. Because if the court decides that these petitions are not maintainable, then automatically the entire creation of the court commissioner and the survey report automatically gets rejected. If the court says that no, these petitions are maintainable, then the court can go into the legality, and the Muslim side will be pressing these, that even if these petitions were maintainable, was the civil court right in passing an order for a survey? And what are the ramifications and implications of the survey itself? So the question of maintainability in itself carries a larger implications of where this hearing will go as a next step. In any case, even if whichever side loses is very, very likely to go to the High Court to challenge that verdict, and then go to the Supreme Court, whichever side is not happy with that. Secondly, what the court has said is what is there on the ground must be protected. What is being called as the shivling by the Hindu side and the fountain by the Muslim side, that structure must be protected. There should be no damage to that structure. The namaz that is being offered in the Gyanvapi Mosque, there should be no obstruction to the namaz either, and there should be proper arrangements made for the wazu as well. And the court has very clearly said that it is for the district administration to ensure that everything goes off without a hitch, that there are no law and order implications on the ground in this area. So the court is trying to do this tightrope walk to sort of find out what the trial court is saying, then what the High Court will have to say, and then we'll see how this plays out by the time this matter comes back to the Supreme Court in the second week of July.
You know, it's a very sensitive order, many would say, but I'm going to bring in Abhishek Mishra, but Anisha, I'm going to ask you a very quick question. What we were discussing earlier, what the Supreme Court said today will not have clearly any legal direct implications on possibly a Mathura court, which is now hearing a plea on the maintainability, whether the mosque, the Shahi mosque, needs to be there or should be taken away or demolished over the Krishna Janmabhoomi. But there will be moral implications of this order there.
Well, Preeti, we should see the legal nuances in all of these. The petition in Mathura is different from the petition in Varanasi, is different from the petition in Delhi, is different from the petition in, say, a Bhojshala. What is there in Mathura at the moment, which is being considered by the district judge, is a plea which says that the 1968 the compromise that had been entered into between the Hindu and Muslim side was fraudulent, and that is why the Hindu petitioners, which are the next friends of Sri Krishna Virajman, are saying that Sri Krishna's land, the land that belongs to Lord Krishna, was illegally given away in a compromise, and therefore that compromise is invalid, and therefore you give us back that land, you remove that masjid. In the Gyanvapi case, on the other hand, it has nothing to do with the land itself. The Gyanvapi case, at the moment, what is being heard right now is that these women, these Hindu women, as devotees of the Ma Shringar Gauri and as devotees of Lord Shiv, are not being allowed to enter that temple every time that they want, or offer rituals and prayers every time that they want, and they are saying this violates our right to worship, and that is why we want that you remove the obstructions that are there. So legally, while on a larger scale, if you look at it like from a layman's perspective, these are essentially Hindu-Muslim matters. But if you look at it legally, the Mathura case is very different from the Varanasi case. And that is why yesterday's order, if you see from the Mathura district judge has said that yes, the civil court can hear this matter for the simple reason that a claim is being made that the 1968 compromise was based on a fraudulent claim to the ownership of the land.
Right.
And that is why yesterday's order from Mathura assumes very great significance, because there the district judge has said that yes, this is maintainable because it has nothing to do with Places of Worship Act. It has nothing to do with right to worship. It is very clearly that the title of the land was illegally given away by somebody who did not have the right to do that. In Gyanvapi case, however, is a very, very different legal issue. So, at the moment, what the court has said, what the Supreme Court has said, will psychologically, yes, on the ground, people, for a layperson to say, think that yes, oh, the Supreme Court has said that the district judge will hear the maintainability, could have an impact. But legally, as far as the courts of law are concerned, they will not be affected.
Right.
Back to you.
All right. You know, stay with me, Anisha. I want to go across to Abhishek as well, but let me quickly now get you the biggest development from the Gyanvapi site. After a shivling was reportedly found inside the well, it's now been claimed that another shivling has been found in the mosque. On your screens are two visuals that look very much like a shivling. The left one shows the disputed claimed shivling in a fountain, and the right one shows a shivling attached to one of the walls of the mosque. Earlier this week, the Hindu side had claimed that there was a shivling near the Wazu Khana of the Gyanvapi Masjid. The Muslim side had disputed the claim and said that it was part of a fountain. But now, pictures of another shivling have cropped up and have added another twist to the entire Gyanvapi saga. So far, the Muslim side has not disputed the claims of the structure in the wall being a shivling. I want to connect right now back to my colleague Abhishek Mishra, who's joining us from Varanasi. Abhishek, coming back to how the people have interpreted this order. Like I said, it's a very, very sensitive order in terms of walking that very tightrope when it comes to the current political and the social context, especially in Varanasi between two communities. Many would say it's a studied, balanced order where neither side, be it the Hindus or the Muslims, can claim a win.
Well, absolutely, Preeti, and the court has given the equal opportunity for both the sides as far as this order is concerned. You know, talking about the maintainability and then transferring this whole case to the district court is something which the court has ordered. And also, very importantly, the court has also continued, the protection of the Shivlinga, also has asked the local administration, the district magistrate, to ensure that the namaz happens at the same time, Wazu and everything which has been there. So that is also a very important aspect as far as this decision is concerned. Now, this whole case has come across because of the survey, the very important survey, which was conducted for 3 days, and then, all those ruckus happening there. And afterward, there was a protest by one side. And, after which, when the report was submitted, there were 2 reports and then one, court commissioner being removed. So all these happenings in the Kashi Gyanvapi survey is a clear indication that how sensitive this whole case is. And Supreme Court also understands the same, that there has to be a balance of act. So that is the reason that this order which has been given looks like that it could not be said that it's a relief for one or a win-win situation for other. It's a balance order, and at the same time, both the sides have an opportunity to, prove their points. But for now, it looks like that there has to be a maintainability, and as far as protecting the shivlinga is concerned, because there are claims, there are photographs, there are substantial evidences, and on the other hand, how the Muslim side has been saying that it is a violation of the Religious Space Act. So for that also to take all these things into consideration, this order looks very promising, and at the same time, it remains to be seen what more reactions will come in. But for now, there is no opposition to it. There is no voices as such, and both the sides have now accepted the fact that what has been said as far as the Supreme Court order is concerned. Yes.
Abhishek and Anisha, we're going to keep coming back to you for the latest, but let's quickly get you more on all the developments that are taking place as a fight over faith rages on. The Kashi temple, Gyanvapi Mosque, India Today has exclusively accessed the book Masire Alamgiri. It is an account of Aurangzeb's rule written by Saki Mustaq Khan, Aurangzeb's last secretary. The documentary proof says that the Vishwanath temple in Varanasi was indeed demolished by the Mughal ruler in the 16th century.
Was a temple demolished to build the Gyanvapi Mosque in Varanasi? The one question that's central to the Gyanvapi Kashi temple case. And now India Today has accessed documentary proof that says that the Vishwanath temple in Varanasi was indeed demolished by Mughal Emperor Aurangzeb. This is the book, Masire Alamgiri. It is an account of Aurangzeb's rule written by Saki Mustaq Khan, Aurangzeb's last secretary. The text clearly mentions that on April the 8th, 1669, Aurangzeb came to know about what he called Brahmin misbelievers teaching their false books to their schools. It further reads, Aurangzeb was eager to establish Islam orders to demolish the schools and temples of the infidels. And so, according to the emperor's wishes, his officers demolished the Vishwanath temple in Kashi.
दीवार दिखाई पड़ती है मस्जिद की, वो उसमें जो मोल्डिंग्स बने हुए हैं वो ब्राह्मणिकल स्ट्रक्चर के होते हैं, प्रायः मस्जिदों के दीवार पर नहीं पाई जाती हैं.
The text was written after the death of Emperor Aurangzeb, but it is about the Mughal ruler's rule from 1658 to 1707. The text clearly mentions that Aurangzeb ordered the demolition of the temple, just like the Hindu side has been claiming in the latest petitions in court.
जैसे घंटी लटकी हुई, उसका वो पत्थर की वो है जो हिंदुओं में होती है, कलश है, फ्लावर मोटिफ हैं जिनसे डिज़ाइन किया हुआ है, ये सारे उसमें उसके मुद्दे होंगे. ये तीन तो होंगे ही होंगे, क्योंकि these are the strongest proof of the fact that a temple existed there.
From, let us say, 1193, there has been a cruel history of demolition of Hindu temples. They are egging them to believe that no demolition was done, or if it was done, it was for political reasons. I think this should stop now. People should acknowledge that this has happened.
History has also witnessed that the temples have been tampered with. The evidence found on the walls of the mosque only show that the mosque was built after the demolition of a temple. A shivling in the wazukhana of the mosque, another shivling in the mosque complex on a wall, and now this testimony of what actually happened during Aurangzeb's reign. Will the courts consider these as they deliberate on the Kashi temple Gyanvapi mosque dispute? Bureau Report, India Today.
All right, viewers, on the big order that's come in from the Supreme Court, joining me in the studio is Vishnu Jain. He's the advocate from the Hindu side who's been fighting the case. I want to cut across to Mr. Jain on primarily, viewers, the orders and the big takeaways that have been passed by the Supreme Court. By prima facie, if you look at it, it's an extremely balanced order. Neither the Hindu side nor the Muslim side can claim a win, at least on what the order has been delivered. It's on a highly sensitive issue, and with what you see right now, the political socio-fabric, which was drawing a communal wedge, it seems to have at least put a balm on that interimly. Vishnu Jain, the biggest takeaways right now, number one, and one can't deny that, is the fact that the case has now been transferred to a district judge, where a civil judge will not be hearing it. The Supreme Court, quote unquote, says a more experienced judge needs to hear it, though no aspersion has been cast on the lower judge.
See, absolutely right. Today in the hearing before the Honorable Supreme Court, the Supreme Court initially formulated the point that we are not casting any aspersions on the capability of the Civil Judge Senior Division, but looking into the sensitivity of the matter, we feel that the matter should be tried by a more seasoned hand, and therefore the matter has been transferred to the District Judge of Varanasi, and they will now decide the matter, and the trial will take place before the District Judge of Varanasi.
So that's a big takeaway, viewers. No longer the civil judge, it will be a higher judge, a district judge, a more experienced judge. The other,
one more thing I want to point out. When the matter has been transferred to the district judge and the trial will take place before the district judge, one stage is cut forth, in the sense that now the first appeal will lie to the High Court and the SLP to the Supreme Court. If it would have been tried by the Civil Judge Senior Division, the first appeal would have been before the District Court. It would have laid a 4-tier system. Now that system is
cut. So you are saying it's cut short the time period, but there's also legal, the very fact that they wanted an experienced judge.
Yes, experienced judge, but now it will be only 3-tier system: District Court, High Court and the Supreme Court.
Fair enough. The other big takeaway, and Vishnu Jain, I'll bring you in on this. When the district judge starts hearing this particular case, it will begin with only one plea, and that will be the maintainability. Whether there's maintainability, the Shringar Gauri case will come later, every other case will come later. They will hear whether there's maintainability on the basis of the 1991 Places of Worship Act, whether it should be allowed to be heard or not.
The order passed by the Supreme Court is that the issue of maintainability must be decided on priority. Now, to decide the issue of maintainability, our contentions of deciding the religious character is so intermixed a question which has to be decided with the maintainability of the suit. Therefore, all these things are left open before the District Judge of Varanasi, and if we are saying that the Places of Worship Act does not apply, we are free to argue that before the district court. And if the Muslim sides are saying that this suit is barred by virtue of section 9 of the CPC and the Places of Worship Act is attracted in this case, they are free to argue their point before the District Judge of Varanasi.
All right, viewers, so I'm going to end it on these two questions. Of course, the other big takeaway is the fact that wazu will be allowed now. Wazu was not allowed earlier. The namazis were told that wazu, come, do your wazu and come and offer prayers. But the court on the other side has also held that the claimed shivling will continue, the area around it will be sealed. So a balanced order there, viewers, but now it's going to be maintainable. All right, relief for Indrani Mukerjea. Indrani Mukerjea is out of jail. She is accused, viewers, of murdering her own daughter. And these are visuals coming in of Indrani Mukerjea getting out of jail. Finally been given bail. She spent over 6 years. She's spent over 6 years in jail, and now Indrani Mukerjea finally walks free. Of course, this is only on bail. It's conditional.
Indrani Mukerjea has walked out of jail after 6.5 years inside a jail in Mumbai. She is accused. She continues to be under trial, but after 6.5 years at the Arthur Road jail, at the Baikala jail, I beg your pardon, she has walked out. She's not a free woman yet, remember. Her lawyers have spoken. Let's try and listen in. Let's try and listen in. We'll make you hear once again those few words that she's just exchanged. She's in her car. She's heading towards her mansion in South Mumbai right now. This is a study in contrast, ladies and gentlemen. 6.5 years inside the Baikala jail, and Indrani Mukerjea now gets into a Mercedes that will take her to her mansion in South Mumbai. She is under trial on charges of murdering her daughter. Let's listen in once again to Indrani Mukerjea.
This legal case ahead, ma'am. Ma'am, what do you see the future of this legal case ahead, ma'am? Ma'am, what do you see the future of this legal case ahead, ma'am?
Okay, Indrani has emerged from jail. She's dyed her hair. Her hair had turned completely white inside prison from the few images that had come out from the Baikala jail over the last few months and years. The kind of toll it has taken on Indrani Mukerjea. 6.5 years in jail is a long time. She remains under trial. She's not been proven innocent. She continues to be under trial on charges of murdering her daughter Sheena Bora, a story that captured the attention of the entire country. These are pictures now, first and exclusive, of Indrani Mukerjea walking out of the Baikala jail, embracing her lawyer and getting into that car that will take her to her South Bombay residence. Relief for Indrani Mukerjea, accused of murder most foul. And now she walks out of jail, and she will continue to be under many court restrictions. She will not be allowed to travel abroad. There will be continuous hearings in her case as well, but on the back of good behavior and meeting certain other criteria. After 6.5 years in jail, under trial, Indrani Mukerjea walks free for the moment. There are lots of stipulations, lots of restrictions on her, but here she is. Her hair is no longer grey. It's been dyed black once again. She has a big smile on her face, a huge contrast, to the very anxious, obviously reasonably anxious look that she bore right through her incarceration. And now she is, for the moment, a free woman, breathing free air in Mumbai, though she continues to be under trial. India Today's Dev Kotak is our man on the ground reporting this big development with Indrani Mukerjea, one of India's most prominent media moguls, who went under a cloud only a few years ago for charges of murdering her daughter Sheena Bora, is now seen walking out of Mumbai's Baikala jail. Let's go straight across to India Today's Dev Kotak, who's with us on the ground. Dev, take us through these scenes, what we're looking at. Where is Indrani headed to now? What next?
To begin with, Indrani is finally a free bird. She has walked out of the jail after 6.5 long years, and the Supreme Court had observed mainly the reason as incarceration, which also her main advocate Sana Rais Khan had argued in the Supreme Court. However, it took 2 long days to complete a couple of formalities at the Sessions Court in Mumbai, and now she is on her way to her residence in the Marlow Cooperative Housing Society in the Worli area of South Mumbai on Sir Pochkanwala Road. Right now, I think she's just going to try and get a breather and enter her house that she has walked out of. Rather, she was forcibly taken out of 7 years back. The first time, August 25 in 2015, she was arrested and rather picked up for questioning. After that, back and forth, there have been several arguments, but in these 7 long years, not a single thing was proven, which also the court observed. And the defense had argued, saying that this case is not making headway. More than 200 witnesses have been examined in this case, but not an iota of proof. However, we know that Indrani's second husband still continues to languish in jail and remain behind the bars. Also, the driver who was the main witness and he turned the police approver, Shyamvar Rai, continues to be in prison. Right now, Indrani is going to try and get a few moments of relief and an absolute breather while she has walked out of the Baikala women's prison after these many long years. But the main reason which her lawyers also argued is the fact that she is suffering from an irreversible mental illness, and on those grounds she be allowed to go. After an amount of 2 lakh of provisional cash bail was paid, only then she was allowed. Yesterday, the entire day was spent in completing those formalities, which is why she had to wait a day longer. And about 5 minutes ago, she has just left the Baikala jail premises after spending a couple of years here. We also spoke to one of her cellmates who said that she was very well behaved. She spoke like a true lady, always interacting with others. But however, mostly she remained to herself. In the jail also, her behavior remained very civil. She interacted, but most of the time she liked to remain in solitary confinement. I think we want to believe that probably solitary confinement and lack of interaction with other jailmates also really affects and sort of impacts the mind. So that could be one reason which could have probably aggravated or impacted her mental illness, which was rather argued in the Supreme Court, and that was also one of the main reasons, and those grounds, medical grounds, is what she was given bail on.
Good behavior is what has gotten Indrani Mukerjea out of jail on bail. Just wanted to give you that study in contrast. Look at those two pictures of what Indrani looked like when she was inside jail and what she looks like right now. An absolute sea change. Her hair had turned completely white inside prison. She was, an image of worry, a fallen face. And there you have a beaming, happy, cheerful, upbeat Indrani Mukerjea walking out of jail. The charges against her are still very grave. That doesn't go away just yet. But Indrani has reason to smile today because today is big relief for her after 6.5 years. 6.5 years inside the Baikala jail. Remember, the drama over her arrest was India's biggest story when Indrani Mukerjea was detained and taken into custody in Mumbai 6.5 years ago on charges of murdering her daughter, Sheena Bora. Murder Most Foul, a crime thriller that captivated the entire nation for weeks together, has come full circle now with Indrani Mukerjea walking out of jail on bail. Good behavior, measured behavior, meeting all the criteria required to, earn a good reputation inside prison as an under trial. She's ticked all those boxes. Obviously, she has the resources to command some of the best legal teams in the country as well. All of these things put together, and Indrani Mukerjea has been able to walk out of jail now. Dev Kota continues to be with us. Dev, these are pretty compelling images, aren't they, Dev? Over the last 6.5 years, every time images of Indrani have come out from the Baikala jail, one couldn't help but be pretty shocked at the transformation. Here was a woman who, in jail had kind of withered away. Her hair had turned completely white. There was this sort of morbid fascination with this woman accused of murder most foul, kind of decaying away in jail. But it's amazing to see the kind of transformation. There's almost a glow about Indrani Mukerjea as she walks out of jail now. She has dyed her hair once again. She's smiling. She's looking upbeat. It's a total makeover.
Yeah, absolutely. Like you said, that when her car when her car drove out of the Baikala jail premises, she waved out to the cameraman and the several media persons that were present there. She greeted them with a wide smile, beaming a lot of happiness, and she was as fresh as a flower. probably looking like a morning water lily because of the fact that she was finally going to get out. And now that she's finally out, I think she has every reason to feel happy and really celebrate at this point in time. And you know, the best part about being out of jail also psychologically and mentally takes you to a different level. These many years that she had spent behind the bars sort of made her a person who had withered away like a, like a really old leaf. But now that she's out, she's poised, she was calm, she just waved to the cameras and she exuded a lot of confidence. But like I said, that mentally and psychologically it does a lot to a person who has remained in jail for almost more than half a decade, in fact. You know, so now at this point in time to be out, it's a momentous occasion. More than anything else, it is the sheer happiness, it is the sheer happiness where you know that nothing concrete or nothing substantial in terms of evidence that has been found against me, and contrary to, especially with the kind of allegations that were leveled against her. Allegedly, she was believed to have, killed her stepdaughter, Sheena Bora. So that is why there were several questions.
And stay with me. I want to go across to Sahil as well. And you're going to hear from Indrani Mukerjea first, an exclusive here on India Today in just a minute. Sahil Joshi, who heads our Mumbai reporting team, live with me. Sahil, big day, crime thriller coming full circle. Indrani with a full makeover, headed out of prison now. What next, Sahil?
Well, it's not going to be easy yet because the trial have already begun in this Sheena Bora murder case, and there are some conditions which she will have to follow. She's right now out on cash bail because she still have to present, in-person surety in front of the court, and for that she has been given 2 weeks time. But yesterday, her lawyers actually pleaded to the trial court that the release order should be passed and she can be released on the cash bail, and that's how 2 lakh rupees cash bail was granted to her, and within 2 weeks she will have to furnish this personal surety. But I have a release order with me, and as you rightly said, our correspondent Vidya has done exclusive interview with Indrani Mukerjea. This is the first interview which I'm sure will be playing out soon. But there are certain conditions which she will have to follow. As I can read the bail order, which is in my hand at this point of time, which says that she should be surrendering the passport to the CBI. She needs to take permission. Without permission, she cannot leave India. She will not influence the prosecution witnesses, which also includes her son Mikhail Bora as well as Rahul Mukherjee as well. They will be coming as a witness in front of the court. Then the third condition she has is that she should be regularly attending the trial and shall she will not seek any kind of adjournment. Then another thing is that she shall not meet or establish contact with witnesses till they record the evidence. That means she will not be able to even speak to her daughter Vidhi, who is also one of the witness in this particular trial. So she will, even if she's out on bail, she will not be able to speak to her family. That is basically Vidhi she's in touch with. Of course, Peter and Indrani are not on talking terms officially. They have filed for divorce. So obviously she will not be speaking to Peter. But at the same time, she will not be able to speak to Vidhi. At the same time, she will not establish any kind of a contact. More importantly, if it clearly says that there are 2 consecutive defaults in appearing before the trial court, breach of any above conditions, the prosecution will be liberty to apply for cancellation of the bail. That means if she does not attend trial without prior permission, twice her bail can be cancelled. Also, she will have to adhere to all the conditions. But more importantly, while speaking to, when she came out, she was wearing a completely different look altogether. As we were seeing that she had dyed her hair. It looks like that she was looking fresh, and her jail stay has also been very controversial. There was a ruckus inside the Bhaikala jail. Bhaikala prison is a women's prison. So when there was an inside fight within the prison, her name had cropped up. She has received a bail in that case as well. She was charged with instigating the jail inmates to create that kind of situation inside the jail. So her jail stay also has not been that clear. She had changed the lawyer as well. There are a lot of things which has happened in last 6.5 years. Now we'll have to see that how the trial goes, because the trial has taken quite a long time, and that is one of the reasons why the Supreme Court said that trial is taking a lot of time. 6.5 years is a lot of time to spend in the prison, and that's why she can be released on the she should be released on the bail. Whereas the Peter Mukerjea was released on the medical bail. He had medical conditions, and that's how he was released on the bail. But more importantly, finally she's out from the prison, which she of course hated. And now we'll have to wait and see, because normally she will not be able to speak much because the trial is on. But of course, that happiness could be seen on her face at this point of time.
Happiness can be seen in her face. I mean, after 6.5 years at the Baikala jail, I think the smile on Indrani Mukerjea's face is the least surprising thing of what's happening here. But, also what a study in contrasts, Sahil. Over the last 6.5 years, there has been a lot of fascination for a woman, who was used to a very opulent lifestyle, living an extremely austere life in jail. It really showed on her face. She's out of jail now, straight into a Mercedes-Benz to go back to that old life. Of course, all those things that you just mentioned still apply. But, Sahil, this is a woman who does have a lot of resources, who did have a lot of resources then. She's got a top legal team as well representing her.
Well, that Mercedes has been provided to her by her lawyer, Sana Sheikh. That's what we were wondering. And she had a lot of bags inside the jail. So that's why it took a lot of time to actually, took out all her goods and the bags she has collected during 6.5 years. She also tried to study law inside the jail. That's what we were hearing. And most importantly, she will have to inform the court that on which address she will be staying once she's released from the prison on bail. So, she will be staying at the same residence where allegedly, that is what is the prosecution case is, that she had kept Sheena's body in the garage in the same residence in Mumbai's Worli area. That is a Marlow apartments where she had kept it, and that apartment has been readied for her. She'll be reaching there soon. It's very clear that during 2012, the investigators said that the body was kept overnight in the car at Marlow. So this is the same place where she's going to stay. So of course she will have to inform the court that what is going to be her residential address, what is going to be her contact details, what she has to do. So that is also another interesting thing. Yeah, it is definitely, and more importantly, it's to furnish this 2 lakh rupees cash bail. Basically, it took a lot of time for her lawyers, because she had come up with 500 rupees notes. So she literally had to write down all the numbers on the notes to present that cash surety to the registrar. So that's why it took a lot of time. Yesterday they received the order. Day before yesterday they received the order. Yesterday the lawyer came down and the procedures were followed. The trial court was on leave, so they had to apply to the in charge bench. The bench which was in charge of CBI cases, and finally they could manage to get her out in the evening today. But as I said, that she could be seen relaxed, because her lawyer, while speaking to media yesterday, had said that in the court she said that her mental condition is not good, and that is the reason why she should be out on bail as early as possible. And that's how she pleaded the court that they are trying to get the personal surety for her, but before that, if she can be released on the cash bail, and that was accepted by the court. And then these very conditions were implied even on Peter Mukerjea as well. The same conditions were followed for Indrani as well. Now both husband and wife out on bail. Shambar Rai, who was the first person to be arrested in this particular case, has been made a prosecution witness. Her husband Sanjeev Khanna is also out on bail. So now nobody is inside the jail, but the trial needs to be fastened. 6.5 years have already been passed. The case was transferred from Mumbai police to the CBI. Then CBI arrested Peter Mukerjea in this case. Before that, only Indrani Mukerjea and Shambar Rai and Sanjeev Khanna, her second husband, Indrani Mukerjea's second husband, were arrested earlier. Peter Mukerjea was arrested after the case was transferred to CBI. So there are lots of twists and turns are going to happen. Rahul Mukerjea, Peter Mukerjea's son, from his first marriage, is also going to be presented as a witness. He'll be coming to the court in next few days, and he's the one who actually pursued the whole case for a very long time. He kept pursuing Indrani Mukerjea as well as Peter Mukerjea to get the whereabouts of Sheena Bora, who suddenly vanished in 2012. He is the one who presented the call recordings with Peter Mukerjea and Indrani Mukerjea, in which they were found to be evading the questions which were put by Rahul Mukherjee with respect to Sheena Bora's whereabouts. So all these things are going to happen. Rahul Mukherjee is going to come to the court in next few days. Of course, Indrani will have to present at the time of trial because she will have to attend a trial, is one of the conditions led by the bail, led by the release order, and the bail conditions given by the Supreme Court as well as the trial court. So it's going to be really interesting drama with even inside the court. Now we'll have to wait and see that what Indrani's lawyers actually put forward their best foot.
Okay, stay with me, Sahil. I also want to go across to Indrani Mukerjea's residence in Mumbai, where India Today's Paras Dama is also standing by with us. Paras, Indrani Mukerjea's vehicle is transporting her home. She's going to be, spending her first night tonight outside jail after 6.5 years. What kind of preparations, if any, are taking place at her residence? I'm assuming there's not too much going on over there, but what can you tell us from where you are?
Of course, there is no much preparation right now outside her residence. This is the same place where Mumbai police has alleged that Indrani Mukerjea has kept Sheena Bora's body for 1 day. So this is the same place where all started, and right now we are standing down where Indrani Mukerjea is going to will be coming in next 20 minutes, because where she was in Baikla jail, it takes 15 to 20 minutes to reach the residence where she stays, and this is a big moment for Indrani Mukerjea because it's been more than 6 years where she was in Baikla jail, she was in prison, and after so many trials, the 7th time she got lucky and she got a bail, and she's on her way from Baikla jail to her residence in Worli. This is the same building where she stays. You can see this is the 5th floor where she stays, and there is no as such preparation has been made for her welcome. You can see the 5th floor, the terrace flat which we are trying to show you. This is the same flat where she used to stay,
She is really happy that she is free.
Please, थोड़ा सा हाँ
बस क्या पूछा
आप अभी वो काफी खुश हैं, क्या कहना चाहेंगी? अभी घर पे जा रही हैं, किस तरफ जा रही हैं?
घर जा रही है वो अभी।
हाँ
घर जा रही है वो अभी।
हाँ और क्या कहना चाहेंगी?
फिलहाल तो कुछ नहीं। रंजीत जी
आगे का क्या प्लान है? क्या
अभी कुछ प्लान अभी कुछ नहीं है। अभी फिलहाल अभी जाके अपना घर जाना है बस।
एक मिनट बाहर कीजिए, आप लोग को ही लगेगा।
जी और क्या कहना चाहेंगी?
एक एक करके
मैम बहुत लंबा वक्त रहा, आगे की शुरुआत कैसी होगी? आप बुक भी लिख रही थी इस पर। अभी मैं कुछ प्लान नहीं कर रही हूँ, अभी आगे जाके पहले घर तो पहुँचूं, फिर उसके बाद देखती हूँ।
विद्या को
Yes,
Indrani, really all the best to you for this.
Thank you.
But I wanted to ask you was, do you blame anyone for this particular incident?
It's all, it's all forgotten.
6.5 years of yours lost.
Empathy and forgiveness. I've forgiven all the people who have hurt me, that's all. So, no blame.
Is there anything you learned in the jail, prison?
Lots.
What?
Lots. Next interview.
Thank you.
Okay, Indrani Mukerjea using big words. Empathy and forgiveness, she says. A woman who's been accused of killing her daughter in murder most foul says empathy and forgiveness is what she would like to, convey to those who've landed her in this situation where she's just emerged after 6.5 years in jail. I'm going to play that out for you once again. Let's play it out. Let's keep playing that out.
Indrani, how are you? What do you have to say? You have to say something. Are you? How's it feel coming out of this prison? You better? What's the first thing you are going to do?
I don't know, I haven't planned.
No plan?
Yes, no.
Okay, very brief exchange between Indrani Mukerjea and India Today's Vidya there. Let's play it out again.
Finally free after 6.5 years. Really happy.
इंद्रानी आप क्या कहना चाहेंगे?
अभी फिलहाल
अभी थोड़ा सा इंद्रानी जी आप क्या कहना चाहेंगी?
अभी उन्होंने काफी कुछ ऑलरेडी शी इज रियली हैप्पी दैट शी इज फ्री
प्लीज थोड़ा सा
रिएक्शन
हाँ
बस क्या पूछा
आप अभी वो काफी खुश हैं, क्या कहना चाहेंगी? अभी घर पे जा रही हैं, किस तरफ जा रही हैं?
घर जा रही हूँ अभी।
हाँ
घर जा रही हूँ अभी।
हाँ और क्या कहना चाहेंगी?
फिलहाल तो कुछ नहीं। रंजीत जी
आगे का क्या प्लान है? क्या
अभी कुछ प्लान अभी कुछ नहीं है। अभी फिलहाल अभी जाके अपना घर जाना है बस।
एक मिनट बाहर कीजिए, आप लोग को ही लगेगा।
जी और क्या कहना चाहेंगी?
एक करके
मैम बहुत लंबा वक्त रहा, आगे की शुरुआत कैसी हो गया? बुक भी लिख रही थी इस पर। अभी मैं कुछ प्लान नहीं कर रही हूँ। अभी आगे जाके पहले घर तो पहुँचूं, फिर उसके बाद देखती हूँ।
विद्या को
Yes, Indrani, really all the best to you for this.
Thank you.
But I wanted to ask you was, do you blame anyone for this particular incident?
It's all, it's all forgotten.
6.5 years of yours lost.
Empathy and forgiveness. I've forgiven all the people who have hurt me. That's all. So.
No blame. Is there anything you learned in the jail, prison?
Lots.
What?
Lots. Next interview.
Thank you.
Okay, Indrani Mukerjea, obviously, under in the company of her lawyer, not saying very much. She's just emerged after 6.5 years in jail. India Today, of course, will be speaking to her first. But, the road ahead for Indrani continues to look uncertain, though today is a day where that beaming smile on her face can most definitely be understood and perhaps justified, given that she is walking out of the Baikala jail as a common inmate after 6.5 years behind bars. India Today's Sahil Joshi continues to be with us on this unfolding story in Mumbai. Sahil, all of us remember the uninterrupted weeks upon weeks of a crime saga that this story sort of rolled out as just a few years ago, 7 years ago. To see Indrani now emerge after 6.5 years, many of us have to remind ourselves of that time. You and I both remember it very clearly because we were involved in the reporting of it. That was easily India's most intriguing suspense and crime thriller, much of it happening in Maharashtra, on the outskirts, the big family of Indrani Mukerjea as well. But just take us through, okay, just coming back to you, Sahil, in just a moment. More voices coming in of Indrani and others. Let's listen in.
Yes, absolutely.
इंद्रानी क्या कहेंगी? साढ़े 6 साल तक आपको रहना पड़ा।
आपको जो बोलना बीच में आराम से बोल दीजिए, आराम से नम्रता। अरे केबल मेरा, अरे केबल भारत भाई, अरे पागल है केबल। इसके लिए बोलता हूँ यार। हाँ बोलिए। आप कोई करना ऊपर ले, क्या कर रहे हो? ऊपर ले काम। अरे उठा रहा है इसको। चलो साइड हो जाओ। 1 मिनट भाई। अरे हटोगे या नहीं हटोगे? वो बात तो थोड़ा तरीके से खड़े रहो। चलो साइड हो जाओ। 1 मिनट। ठीक है, 1 मिनट। मैं मिक्स आप आ जाइए।
1 मिनट।
अरे हटोगे या नहीं हटोगे? थोड़ा बोलो ना, बात करने दो उनको। 1 मिनट। वो बात तो थोड़ा तरीके से खड़े रहो।
1 मिनट मधुकर, 1 मिनट
आराम से। 1 सेकंड। बस।
Indrani Mukerjea has reached home. She's reached her home in Mumbai right now. We will be doing a chat with Indrani in a short while from now, but Indrani obviously not wanting to say very much as she walks out of jail after 6.5 years. Indrani Mukerjea has spent 6.5 years in the Baikala jail. She walks out now fully made over and has headed home in the company of her lawyer, Sana Rais Sheikh. She's talked about empathy and forgiveness. I want to play out for you once again everything that Indrani Mukerjea has just said. Remember, she continues to be under trial.
Yes.
Indrani, really all the best to you for this.
Thank you.
But I
Thank
wanted
you
to
so
ask you was, do you blame anyone for this particular incident?
It's all, it's all forgotten.
6.5 years of yours lost.
Empathy and forgiveness. I've forgiven all the people who have hurt me, that's all. So,
Is
is
there anything you learned in the jail, prison?
Lots.
What?
Lots. Next interview.
Thank you.
Indrani Mukerjea is now inside her house in Mumbai. She obviously won't be speaking anymore to journalists at this point of time. Journalists have done their job by trying to get those reactions, from a person who's just walked out of jail after 6.5 years. Her estranged husband, Peter Mukerjea, from whom she separated from while during her incarceration at the Baikala jail, is not there, obviously.
इंद्रानी आराम से पैर पे नहीं चढ़ना आपको प्लीज
सर बाहर जा रहे हैं
A huge number of restrictions on Indrani Mukerjea. She cannot contact her children. Her children live in different parts of the country and the world. She cannot be in touch with them. There are various other restrictions, obviously, on her travel as well. She has to attend every hearing without fail. She's committed to doing so. There are many things that she's had to sign off on as she has been granted bail. The underpinnings of the smile on Indrani Mukerjea's face as she walks out of the Baikala jail has been her good behavior inside prison, and she has now talked about empathy and forgiveness, adding another intriguing layer to this continuing crime saga. Empathy and forgiveness. Forgiveness of who? Who is she pointing at? There are so many questions, and we, of course, here in India Today will ask those questions. We'll get you true accounts of what is happening in this case, the latest, as the release of Indrani Mukerjea becomes the focal point and an opportunity to revisit this entire crime saga that only 6.5 years ago had an entire nation completely enthralled and captivated. After 6.5 years in Mumbai's Baikala jail, Indrani Mukerjea, those are the pictures you're looking at right now, has walked free but under bail. A prime accused in the murder of her daughter Sheena Bora, Indrani has just returned to her plush residence in South Mumbai's Worli area, which bears the shadow of the Sheena Bora murder. Here's a report on why Marlow, the residence where Indrani is in right now, is once again in the spotlight.
Marlow, a duplex flat in South Mumbai, is once again in the spotlight. This is where former TV tycoon and murder accused Indrani Mukerjea will stay after walking out of the Baikula jail, which has been her home for the last 6.5 years. The 3,000 square feet house was once jointly owned by Indrani and her former husband and co-accused Peter Mukerjea. The murder-accused couple split the sprawling floors after divorce proceedings. Marlow is a house crawling with secrets. Investigators believe it was here that Indrani kept her daughter Sheena Bora's body.
एक मिनट
हटोगे या नहीं हटोगे? थोड़ा बोलो ना, बात बोलने दो उनको। एक मिनट वो बात तो थोड़ा तरीके से
6-7 बैनर्स निकल रही हैं। एक आपका रिएक्शन दे दीजिए मैम, किस तरह की?
बस रिएक्शन में थैंक यू फॉर योर सपोर्ट। बहुत आप लोगों ने साथ दिया, थैंक यू फॉर दैट।
थैंक यू गाइस।
चलो फोन नीचे रखो है। आपको कुछ तो बोलिए प्लीज, अलिफ में है आप बोल सकते हैं।
थैंक यू फॉर एवरीथिंग, थैंक यू फॉर योर सपोर्ट।
हाँ ओके, थैंक यू।
ओके थैंक यू। नहीं बस फिलहाल इतना ही बात।
निकल रही हैं, एक आपका रिएक्शन दे दीजिए मैम, किस तरह की?
बस रिएक्शन में थैंक यू फॉर योर सपोर्ट। बहुत आप लोगों ने साथ दिया, थैंक यू फॉर दैट।
थैंक यू गाइस।
चलो
बंद कर दिए। ओके फोन नीचे रखो है नहीं। थैंक यू। कौन हाँफ रहा है यार, बहुत जोर।
We're going to stay on these live images. We're going to stay on these live images of Indrani Mukerjea, who has just reached her residence. I want to play out for you everything that Indrani Mukerjea has just said. She has, said a number of things since she's emerged out of prison and walked into her house just a moment ago. So we're going to stay with these images and get you more and more of what she's said. We know this is a story of extremely high interest, and that's why we're going to continue to bring you the latest. Let's listen in once again.
मधुकर एक मिनट
आराम से।
Yes, Indrani, really all the best to you for this.
Thank you.
But I wanted to ask you was, do you blame anyone for this particular incident?
It's all, it's all forgotten.
6.5 years of yours lost.
Empathy and forgiveness. I've forgiven all the people who have hurt me, that's all. So.
Is there anything you learned in the jail, prison?
Lots.
What?
Lots. Next interview.
Indrani Mukerjea, in an exclusive exchange with India Today, talks about forgiveness and empathy. Let's go back to that. Let's keep playing that out, because that's the one comment that she's made exclusively to India Today. Let's play that out again.
Yes, Indrani, really all the best to you for this.
Thank you.
But I wanted to ask you was, do you blame anyone for this particular incident?
It's all, it's all forgotten.
6.5 years of yours lost.
Empathy and forgiveness. I've forgiven all the people who have hurt me, that's all. So.
Is there anything you learned in the jail, prison?
Lots.
What?
Lots. Next interview. Yes.
Indrani, really all the best to you for this.
Thank you.
But I wanted to ask you was, do you blame anyone for this particular incident?
It's all, it's all forgotten.
6.5 years of yours lost.
Empathy and forgiveness. I've forgiven all the people who have hurt me, that's all. So.
Is there anything you learned in the jail, prison?
Lots.
What?
Lots. Next interview. Yes.
Indrani, really all the best to you for this.
Thank you.
But I wanted to ask you was, do you blame anyone for this particular incident?
It's all, it's all forgotten.
6.5 years of yours lost.
Empathy and forgiveness. I've forgiven all the people who have hurt me, that's all. So, no blame.
Is there anything you learned in the jail, prison?
Lots.
What?
Lots. Next interview.
To play out for you what more Indrani has just said. Indrani Mukerjea has just said journalists have spoken to her outside the prison when she came out, in her car as she was getting there, and also once she reached home. Let me play out for you everything, all the comments that Indrani Mukerjea has made since she came out of prison, in case you missed any one of them. The only direct comment is, of course, to India Today's Vidya.
Yes, Indrani, really all the best to you for this.
Thank you.
But I wanted to ask you was, do you blame anyone for this particular incident?
It's all, it's all forgotten.
6.5 years of yours lost.
Empathy and forgiveness. I've forgiven all the people who have hurt me, that's all. So, no blame.
Is there anything you learned in the jail, prison?
Lots.
What?
Lots. Next interview.
रिलैक्स होके आपको जो बोलना बोलो बीच में आराम से बोल दीजिए आराम से नम्रता
अरे केबल मेरा अरे केबल भारत बैग अरे केबल
इसके लिए बोलता हूँ यार हाँ बोलिए आप कोई करना ऊपर ले क्या ऊपर ले काम चलो साइड हो जाओ एक मिनट अरे हटोगे या नहीं हटोगे बोलो ना बात तो बोलने दो वो बात तो थोड़ा तरीके से खड़े रहो
मधुकर 1 मिनट
आराम से 1 सेकंड मैडम बस इसके आगे कोई नहीं जाएगा अभी मैडम पीछे धक्का मत दो कोई नहीं आपको कुछ तो बोलिए प्लीज लिफ्ट में है बोल सकती हैं
थैंक यू फॉर एवरीथिंग थैंक यू फॉर योर सपोर्ट
हाँ ओके थैंक यू और कुछ
India Today's Vidya is live with me from Mumbai. Vidya happens to be the only journalist whose questions were directly answered by Indrani Mukerjea, and possibly the only comment that has any real significance has come directly in response to Vidya's question. She joins me live. Before I go to Vidya, let me play out for you once again what Indrani Mukerjea said to Vidya. Listen very carefully. Empathy and forgiveness is what Indrani says directly to India Today's question. Listen into this.
Yes, Indrani, really all the best to you for this.
Thank you.
But I wanted to ask you was, do you blame anyone for this particular incident?
It's all, it's all forgotten.
6.5 years of yours lost.
Empathy and forgiveness. I've forgiven all the people who have hurt me, that's all. So, no blame.
Is there anything you learned in the jail, prison?
Lots.
What?
Lots. Next interview.
Vidya is with me live. Vidya, I wanted to ask you, she said all sorts of, very non-committal things to other journalists. But, obviously, considering that India Today's journalists are taken seriously, you've been a crime reporter for many, many years. You tracked this story very, very closely. I'm sure Indrani even recognized you, Vidya, from your amazing reportage 6.5, 7 years ago. She chose to answer you and you alone, Vidya. And she used very, very significant words, empathy and forgiveness.
Well, that's the plan that she really has. In fact, she's back in this house, this particular house, Marlow Bungalow. This is where Indrani was arrested 7 years ago. And after spending nearly 7 years behind prison, especially in one cell of the Baikala prison, she has come back now. And certainly that was the reason why I wanted to ask her, what's the plan ahead? Because remember, when she was arrested, Indrani and Peter, who were married at that time, had a plan to wrap up all their businesses and go to UK. But now what? After 7 years, what would she be picking up from the pieces of whatever her life is left about right now? And that's the reason I really wanted to know what she was planning to do. And she said that right now she just wanted to get home, take rest, and then she would decide what would be the next course of action. But she certainly seemed to be someone who has always been the person with a plan, and she certainly seems to be someone who will work out on that plan in some time from now.
How do you see this going for her, Vidya? How do you see this going for her? Is she going to... Obviously, she's going to be a very, very private person. I don't think she's going to make very many public appearances apart from going to jail. But, what's the sense you're picking up? Obviously, it's going to be a very, very closeted existence because that's what her lawyers also will want.
Well, remember, this case is still sub judice. Out of the 200 witnesses, there are about only 60 to 70 witnesses who have been brought to the court. Some of the important witnesses like Rahul Mukherjee, Vidhi, her own daughter, they are yet to be produced in court as witnesses. So the case is going to take a while. So at this juncture, what Indrani certainly is not going to speak on the case per se, because she believes that, whatever she says will hurt her case. At the end of the day, that's the reason when I asked her about the case, she refused to speak much except saying that there is empathy, forgiveness, she doesn't blame anyone. But certainly there would be something that she might want to speak about later when the case is over, whatever comes out of it. At one point when the case is over, she might want to speak, but not right now because the case is sub judice. But we'll certainly try asking her the questions again.
I have one more question for you, Vidya, but I want to play that out again because, this has added a new layer to this very morbid and fascinating saga. Let me play out for you once again, viewer, what Indrani Mukerjea, let me repeat this once again. The only journalist she has responded to directly is Vidya, who is with me live. Listen into what Indrani said to Vidya just now.
Yes. Indrani, really all the best to you for this.
Thank you.
But I wanted to ask you do you blame anyone for this particular incident?
It's all, it's all forgotten.
6.5 years of yours lost.
Empathy and forgiveness. I've forgiven all the people who have hurt me, that's all. So,
Is there anything you learned in the jail, prison?
Lots.
What?
Lots. Next interview.
Vidya, when she says empathy and forgiveness, obviously like this case is sub judice, so we can't conjecture on anything. But as a journalist who has reported this threadbare, this entire saga, what do you think she meant? Who does she blame for what has happened to her?
Well, at this juncture, certainly, someone who has been behind bars and who really thinks that there is nothing that is there in this case, and whatever case that has been built up by first the Mumbai police and the CBI is all hoopla and there's nothing in this case. So Indrani does believe that, and that's one of the reasons why I'm sure at some point she would say that the CBI has concocted a story, which she has of course been saying also. The entire story is concocted, and remember, some time back she had written a letter to the CBI director asking that one of the Mumbai police inspector Korke's interview that statement should be recorded, because she says to her in the prison that Sheena was alive and she had met her in Dal Lake in Kashmir. So these kind of things probably is one of the reasons why Indrani feels this entire story is concocted by the agencies to probably do something wrong to her, to probably make her do something else. But certainly at this juncture, she says that it's sub judice, so will not talk about it.
Okay, it's sub judice. She's not going to talk about it. She says she's very happy. She's relieved to be out. But, she's going to be looking for empathy and forgiveness for those who've landed her in this situation where she comes out of jail after 6.5 years. Vidya, I'll leave it there for the moment. Thank you very much for joining us and throwing light not just on Indrani, but also what next in this entire saga. Remember, Sheena Bora, the murder of Sheena Bora, is a story that very few people are not familiar with, given the depth to which the media had covered this story, less than a decade ago. It's a story that played out, and had angles in different parts of the world as well. Sheena Bora, the daughter of Indrani Mukerjea, who was murdered. Her remains were found not very far from Mumbai. Has become one of the most grisly crime sagas that the country, has been glued to in many, many years. And now one of the accused in the case, Indrani Mukerjea, the mother of Sheena Bora, has walked free. She continues to be a murder accused, but she's out on bail on the back of good behavior and meeting several other criteria that allows her this relief. So now, under the care of her lawyer, the very well-known Sana Rais Khan, Indrani Mukerjea is back at her home in Mumbai's Worli area. The fascination, the captivation, the interest in this case will no doubt flare up once again with Indrani Mukerjea breathing free air. India Today, unsurprisingly, is the only channel that Indrani Mukerjea has directly answered in this entire case. So we're going to stay with these visuals. We're going to play out for you once again what Indrani Mukerjea has said since she came out of jail. Let's just play out for you all those sound bites once again.
Yes.
Indrani, really all the best to you for this.
Thank you.
But I wanted to ask you was, do you blame anyone for this particular incident?
It's all, it's all forgotten.
6.5 years of yours lost.
Empathy and forgiveness. I've forgiven all the people who have hurt me, that's all. So,
Is there anything you learned in the jail, prison?
Lots.
What?
Lots. Next interview.
And Asaduddin Owaisi, Hyderabad MP, holding a big press conference on the Gyanvapi Supreme Court order. Let's listen in.
आप नहीं कर सकते इसका ऑब्जेक्शन अहमदी साहब ने लिया और आप पढ़ लीजिए क्या कहा जजेस ने। बोले कि हम मिसाल दे रहे हैं, तो वो ऑर्डर का हिस्सा नहीं है। तो 91 का एक्ट क्यों बनाया गया? 91 का एक्ट बनाया गया टू प्रिवेंट फ्यूचर कंट्रोवर्सीज। और हम तो ये उम्मीद कर रहे हैं कि चाहे सुप्रीम कोर्ट हो, लोअर कोर्ट हो, हाई कोर्ट हो, वो जो बाबरी मस्जिद के टाइटल सूट में सुप्रीम कोर्ट ने कह दिया कि 91 का एक्ट भारत के संविधान के बेसिक स्ट्रक्चर का हिस्सा है, हम पूरे कोर्ट्स को चाहेंगे कि उसको इम्प्लीमेंट करें। वो 91 का एक्ट भारत के संविधान का बेसिक स्ट्रक्चर का हिस्सा है, इसमें कोई दो राय नहीं है, क्योंकि सुप्रीम कोर्ट ने कह दिया उसको। और जो अंग्रेजी में कहते कि वॉक द टॉक होना चाहिए अभी।
लेकिन सर, आप इसको बार बार फाउंटेन है बोल के बोल रहे हैं, पर ये तो ऑब्जर्वेशन है ना कि ये शिवलिंग माना जा रहा है।
नहीं, वो देखिए, जो कोर्ट के जज ने बगैर मुस्लिम पक्ष को सुना, बगैर सर्वे कमिश्नर की रिपोर्ट जज साहब के पास गई, जज साहब ने दूसरी पार्टी जो दौड़ती है उनके पास गई, उनको सुना, और बगैर मुसलमान को जो पार्टी है उसमें इंतजामिया कमेटी, बगैर सर्वे कमिश्नर की रिपोर्ट में उन्होंने गलत ऑर्डर दिया। इसीलिए सुनिए, ये सुप्रीम कोर्ट में बात रखी गई और हम सुप्रीम कोर्ट ने अब डिस्ट्रिक्ट मजिस्ट्रेट के पास इस केस को भिजाया है और हम उम्मीद करते हैं कि वो फेयर तरीके से इन तमाम चीजों को सुनेंगे।
लेकिन आप
सर डिटरमाइन कर सकते हैं, सुप्रीम कोर्ट ने ये कहा,
ऐसा नहीं, नो
और अब तो अरेंजमेंट करने के लिए भी
नहीं, आप गलत कह रहे हैं। क्या वो ऑर्डर का हिस्सा है आज के? नहीं, देखिए, जो जजमेंट में कहा जाएगा वही फॉलो किया जाएगा। और सुप्रीम कोर्ट ने एक मिसाल देकर कहा, अगर आप ये बोलेंगे कि मस्जिद में किसी और की निशानी मिल जाएगी तो क्या मस्जिद का कैरेक्टर चेंज हो जाएगा? वही नहीं, नो, ऐसा नथिंग डूइंग। वो गलत, आप लोग गलत रीड कर रहे। आप किसी भी सीनियर लॉयर को बिठाकर पूछ लीजिए जो मुझसे काबिल है, वो बोलेगा कि 91 एक्ट ये कहता है कि नेचर एंड कैरेक्टर चेंज नहीं हो सकता। और आप बार बार जो सर्टन की बात कर रहे हैं, वो एक मिसाल के तौर पर कहा गया। जो आज के ऑर्डर में रिफ्लेक्ट नहीं है।
सर क्लियरली मैं आपको पढ़ के बता दूंगा।
हाँ, पढ़ के ऑर्डर बताइए। नहीं सुनिए, नहीं आप ऑर्डर पढ़िए।
सपोज
ऑर्डर पढ़, नो सपोज नथिंग, आप ऑर्डर पढ़िए।
सर जस्टिस चंद्र,
नहीं आप ऑर्डर पढ़िए। आप सुनिए, देखिए ऐसा नहीं हो सकता। आप नहीं, मैं आपकी बात का यकीन ही नहीं कर सकता। आप आज का ऑर्डर पढ़िए। चलिए बताइए मेरे को उसमें क्या है।
सर आप कह रहे हैं कि मुस्लिम पक्ष को बिना सुने ही उन लोगों ने वहाँ पे अरेंजमेंट्स करने के लिए वो प्रोटेक्शन करने के लिए कहा, लेकिन आज सुप्रीम कोर्ट ने कहा कि अरेंजमेंट्स होने चाहिए वहाँ पे वजू करने के लिए।
हाँ, तो सुनिए, जब अहमदी साहब ने कहा कि क्यों अल्टरनेट अरेंजमेंट, तो कोर्ट ने कहा अल्टरनेट अरेंजमेंट नहीं। सुनिए, सुन तो लीजिए। अल्टरनेट अरेंजमेंट ने क्यों जब पूछा गया तो कोर्ट ने कहा कि पानी मुहैया किया जाना चाहिए। पानी कहाँ मिलेगा? पौंड में मिलेगा। नहीं मिलेगा। पानी पौंड के सामने नल की टूटियां हैं, वहीं पानी मिलेगा। और पानी कहाँ मिलेगा? कोर्ट ने कहा कि हम अल्टरनेट अरेंजमेंट की बात नहीं कर रहे। कोर्ट ने कहा अभी डायरेक्ट का लफ्ज इस्तेमाल हुआ है, और उस पॉन्ड्स के पास, वो पॉन्ड को और उस पॉन्ड में जो नल की टूटियां हैं उसको इस्तेमाल करेंगे वजू करने के लिए।
सर ऐसे जो रेफरेंस किया प्लेसेस ऑफ वर्शिप एक्ट पे, इस पे आपका क्या कहना सर? क्या ये जो प्लेस सिंबल, ज़ोरास्ट्रियन सिंबल पाए गए
रेफरेंस के तरीके से।
अरे सुनिए, देखिए वो उसके लिए लंबी बहस हो जाएगी। आप मेरे को बताओ वो जो आज के ऑर्डर में कुछ है क्या वैसा? बताइए
सर। जस्टिस
नो सी, these are exchanges which the judges and the lawyers will have. Are you trying to elevate it to the judgment? Don't elevate that to the judgment.
But sir, there is a report which was leaked yesterday.
So yes, what did the court say on that? The report should not have been leaked, but the damage has already been done.
But report also shows that they are evidence.
The court has said the report should not be leaked. Now it has been gone to a district magistrate, and on priority 711 order 711 will be heard. That is the maintainability of this whole suit. कुछ रुक जाइए।
91 के कानून की बात कर रहे हैं हर मामले में। क्या मुस्लिम पक्ष इस मसले को लेकर एक अलग से कोई मूवमेंट या कोई ऑर्गेनाइज ढंग से इसको स्थापित करने के लिए कोई अपील दायर करेगा?
क्या है फिर से बोलिए।
तो 91 का हमेशा हवाला दे रहे हैं, हर मामले में दे रहे हैं।
हवाला आपको भी देना चाहिए, तो कानून है वो।
तो क्या उसको मुस्लिम पक्ष पूरे टोटालिटी में ऑल इंडिया लेवल पे कोई जाके उस कानून के लिए आप लोग कुछ करने वाले हैं कि
नहीं? कानून को करने क्या वो तो बेसिक स्ट्रक्चर का हिस्सा है, पार्लियामेंट का बनाया हुआ कानून है। हमको करने की क्या जरूरत है? हम इतना ही कह रहे कि सुप्रीम कोर्ट ने जब ये कह चुका कि ये बेसिक स्ट्रक्चर का संविधान का हिस्सा है, तो हम तो ये उम्मीद कर रहे हैं कि कोर्ट्स वॉक द टॉक करेंगे, बस और कुछ नहीं। हमको वो बेसिक स्ट्रक्चर का हिस्सा है पैराग्राफ नंबर 83 में, और ऑनरेबल जस्टिस चंद्रचूड़ साहब उस जजमेंट के जजेस में से हिस्सा थे।
Sir, Justice Chandrachud also said.
No. See, I am sorry. You are ignorant about this law. You cannot call the exchanges between the honorable judges and the lawyers as a judgment. Please don't do that. No, please don't do. No, don't do that. No, don't do it. You are completely on the wrong path.
So first of all, order copy is not out.
In fact, I am telling you, you will be hauled for contempt of court. Don't do it.
Order copy is not out yet.
So order copy is there. You see on the live law, bar and bench, it is there. Go and see it.
सर सुप्रीम कोर्ट में ये तेलंगाना के मुतालिक एक इनकाउंटर हुआ था, उसके मामले में भी कुछ डेवलपमेंट आया।
मैं हर एनकाउंटर के खिलाफ हूं, चाहे वो चंद्रबाबू नायडू के जमाने में अजीज और आजम का एनकाउंटर हो, चाहे सोहराबुद्दीन का एनकाउंटर हो, चाहे वो नईम का एनकाउंटर हो, चाहे ये जो शमशाबाद में एनकाउंटर किया गया है। मैं हर एनकाउंटर के खिलाफ हूं, क्योंकि एनकाउंटर रूल ऑफ लॉ को कमजोर करता है। हम रूल ऑफ लॉ से सरकार चलनी चाहिए, रूल बाय गन से नहीं चलनी चाहिए। बस मैं इतना ही कहूंगा इस मामले में।
Sir, if you want, I'll exactly.
No, I don't. No, you are completely ignorant of the law.
Hello and welcome to an India Today special broadcast that comes to you from the banks of River Ganga in Kashi. I'm Gaurav Sawant. A large number of people have assembled here on the banks of River Ganga to celebrate an evening out. It's almost like a festival of sorts here on the banks of Ganga in Kashi. There are parks, there are playgrounds, there are people enjoying a cup of tea. There are also people who are taking a ride on the boat. And amidst all this, as we wait for the Ganga Aarti on the banks of Ganga, the main topic of conversation across is the Supreme Court talking about the Kashi Vishwanath and Gyanvapi Mosque, the entire debate, and saying that the matter should be heard on priority by the district judge. The Supreme Court transferred the Gyanvapi case to the district judge and directed that a senior judge hear the case after summer vacation on priority, indicating that on the 17th, this happens in the second week of July. The May 17th order for ensuring that religious rituals at the mosque and the reported shivling remain protected. That's crucial. The shivling will remain protected, which means that the Wazukhana area will remain sealed off. The district administration has been directed to make alternate arrangements so that the namazis are able to carry out their religious activities, but not where the Hindu side insists a shivling exists and has been located, and the Muslim side continues to insist that that is a fountain. Devotees gathered outside the mosque to offer Friday prayers. The Masjid committee appealed to come to people in smaller numbers because the Wazukhana had been sealed off. But a large number of people came earlier today, and such was the situation that at one point of time, the mosque management committee said there is no more place for more namazis to come there. But let me get you the day's developments right on top.
अब जो माननीय सर्वोच्च न्यायालय का आदेश है वो मान्य होगा, जो देखा जाएगा उसको, जो एपेक्स कोर्ट ने जो आदेश दिया है वो उचित व जायज है। 10:15 में चूंकि सब मैंने रिपोर्ट ये सबमिट कर दी थी, उसके बाद माननीय सिविल जज कोर्ट में ये दाखिल था। उसके बाद अगर कुछ हुआ हो तो जानकारी नहीं, अभी उसके पहले तक कोई लीक नहीं हुआ था।
देखिए, सुप्रीम कोर्ट ने इस मैटर का ट्रायल डिस्ट्रिक्ट जज के सामने ट्रांसफर कर दिया, डिस्ट्रिक्ट जज वाराणसी के सामने। दूसरी बात, जो सुप्रीम कोर्ट का इंटरिम अरेंजमेंट था 16 मई का, वो होगा। तीसरी बात, जो उनका वजू के लिए वो अरेंजमेंट मांग रहे थे, कोर्ट ने कहा उसके लिए अरेंजमेंट किया जाए। पर जो 16 मई का ऑर्डर है सुप्रीम कोर्ट का उस एरिया को सील करने का, वो बरकरार रहेगा। 16 मई, हाँ सॉरी 17 मई का ऑर्डर बरकरार रहेगा। जो मुस्लिम पक्ष की एप्लीकेशन है 7/11 की, वो भी प्रायोरिटी पे डिसाइड होगी। ये चार बातें मुख्यतः सुप्रीम कोर्ट ने आज कही हैं, और ये भी बात कही है कि जो हमारी एडवोकेट कमीशन की रिपोर्ट है वो भी उसको कंसिडर करने में कोई रोक नहीं है। उनकी एप्लीकेशन प्रायोरिटी पे डिसाइड होगी, पर बाकी चीजें भी इस समय डिस्ट्रिक्ट जज के सामने खुली हुई हैं, वो कैसे प्रोसीड करना चाहते हैं ये माननीय डिस्ट्रिक्ट जज वाराणसी का अब प्रेरोगेटिव। 7/11 की एप्लीकेशन होती है, जो मुस्लिम पक्ष का ये कहना था कि जो हमने सूट फाइल किया है वो मेंटेनेबल नहीं है, वो सूट चल नहीं सकता है। उसके लिए उन्होंने 7/11 की एप्लीकेशन डाली थी, मतलब इसको इमीडिएटली रिजेक्ट किया जाए। तो कोर्ट ने कहा है कि डिस्ट्रिक्ट जज वाराणसी उसको कंसिडर करेगा, और जो बाकी चीजें हैं वो भी कंसिडर की जाएंगी, और ये ही 7/11 का मतलब है मेंटेनेबिलिटी ऑफ द सूट का।
उनका आधार क्या था? क्या प्लेस ऑफ
उनका ये आधार था कि ये सूट प्लेसेस ऑफ वर्शिप एक्ट से बार्ड है। तो माननीय सुप्रीम कोर्ट ने कहा कि वो बार्ड है कि नहीं बार्ड है, ये डिस्ट्रिक्ट जज वाराणसी देखेंगे, उस पर अभी हम कोई कमेंट नहीं करना चाहते हैं। और ये जो SLP है पेंडिंग है, ये जुलाई में सेकेंड वीक में लगेगी।
So you're hearing all sides of the story here, and the Supreme Court also said maintaining peace is extremely important, and that is also one of their tasks, as they heard all sides to this dispute. Adding to this dispute, there's another image of a shivling that has come out today. India Today gets you those images. Now, we are on the banks of River Ganga. This is the famous Assi Ghat, and all eyes on the Ganga Aarti that will take place in a short while from now. And people from all walks of life. It's not as if only Hindus are coming here. Hindus, Muslims, people of Kashi, Avinashi Kashi, a city that is said to be nestled on the trident of Lord Shiv. This is what Kashi is known as, the eternal city where everyone lives in peace and harmony. And despite this dispute, people are living in peace and harmony here, giving each other ample space to vent, to bring out their points of view, and then leave it to the courts to decide what the next course of action will be. But before that, this report about the second shivling being found. Remember, the first shivling has been disputed by the Muslim side that calls it a fountain. But the second shivling, take a look at this report.
A second shivling on the wall of the Gyanvapi Mosque complex has triggered massive suspense. The latest images come just days after videos of another claimed shivling in the Wazukhana of the mosque emerged. The claim of the shivling in the Wazukhana has been contested by the Muslim side, which calls the structure a fountain.
The demolition is well known. It is historically recorded by the historians of the period. There is no doubt about it. Whether a single object discovered there belongs to the temple complex architecture or it does not, it is not of great consequence. As far as I have seen the picture, it does appear to be a shivling. But obviously, close examination will be conducted.
But the second shivling is uncontested and undisputed. Ensconced in the wall, surrounded by lotus imagery.
Disc-like or tablet-like thing has been placed over it, and the mortar is seen. The white color mortar is seen, and perhaps white cement-like thing. And which was fixed over it, and just to distort the evidence of shivling.
The Hindu side claims that the Gyanvapi Mosque was built after the Kashi Vishwanath temple was demolished by Aurangzeb. The shivling in the mosque wall could be a big push for the claim and could settle the shivling dispute forever. Bureau Report, India Today.
And I want to quickly cut across to India Today's Ajay Mishra for more on this big story. Abhishek, after the Supreme Court verdict, and you've been speaking to a cross-section of people, what's the first reaction that's coming in? What's the reaction that you are picking up on ground?
Well, absolutely, Gaurav. This decision has come as a very important development as far as this Gyanvapi case is concerned. So far, both the parties, here the Hindu side or the Muslim side, are not speaking much. They are going by with the order. And very importantly, the order states about the maintainability of the Gyanvapi Mosque. And at the same time, how the Muslim side has been very vocal about stopping this survey, and at the same time was demanding to rest the situation as it is. But with this order, the Supreme Court has made it very clear that it should pass on to the district court. They should listen to it, and at the same time, they have maintained the order of maintaining the namaz is there, use of Wazukhana, and at the same time also has instructed the local administration to make sure that the things are under control. So in a way, it is not a win-win or a loser situation for any of the sides. It is a balance of fact, and the court is taking time in order to make sure, because this is a very sensitive issue, and we have been witnessing throughout the survey when it was conducted, the court commissioner being changed, and then the Muslim side being very vocal about the stance of the survey. So certainly kind of missed reactions, and for now, both the sides are eventually now following the order and speaking not much as far as this order is concerned. Yes.
The fortunate thing is, despite some trying to inflame passions, people have by and large remained very, very careful about this. And, even as we speak, I'm joined by Sarfaraz Ahmad. He's a prominent Muslim leader here in Kashi, and Sarfaraz Ahmad joins me on the broadcast. Supreme Court का आदेश जिस तरह से आपने देखा, जो मुस्लिम पक्ष ये मांग कर रहा था कि सर्वे को रोक दिया जाए या सर्वे रिपोर्ट पर ध्यान ना दिया जाए, उसको वो 1991 के प्लेसेस ऑफ वर्शिप एक्ट के विरुद्ध है। सुप्रीम कोर्ट ने उस पक्ष को फिलहाल नहीं माना, ये कहा कि डिस्ट्रिक्ट जज तय करेंगे। किस तरह से आप देखते हैं सुप्रीम कोर्ट के इस आदेश को?
मैं सरफराज अहमद, राष्ट्रीय बुनकर एक्शन कमेटी का अध्यक्ष। शुरू अल्लाह के नाम से जो निहायत रहीम और रहम करने वाला है। मैं बड़े भाई एक बात, ये पिटीशन जो दाखिल हुई थी, जो हमारी बहनों ने माँ श्रृंगार गौरी के लिए पूजा अर्चना के लिए की थी, वो पिटीशन कहाँ से कहाँ घूम रही है और मालिकाना हक की तरफ मुतब्बिल हो गई। तो ये क्या मतलब है? जब एक कमीशन रिपोर्ट अभी आई ही नहीं है और कमीशन रिपोर्ट आते आते में तो फरमान आ गया कि पेशाब खाना बंद कर दो, वजू खाना बंद कर दो। अरे सुप्रीम कोर्ट कहा कि पेशाब खाना और रास्ता कभी नहीं बंद किया जा सकता, वो भी आपने बंद कर दिया। मस्जिद में कितनी दिक्कत हुई। खैर हमारे सुप्रीम कोर्ट ने इसका इल्म रखा और वैकल्पिक इंतजाम के लिए जिला प्रशासन को कहा, मैं उसका तहे दिल से खैर मकदम का। सुप्रीम कोर्ट अगर कुछ सोच रही है, कह रही है, तो उसमें कुछ जरूर अहमियत होगी।
लेकिन मैं आपसे ये पूछना चाहता हूँ, चलिए काशी में हम हैं इस समय, गंगा नदी के तट पर है, तो माँ गंगा एक तरफ है, सुंदर मंदिर दूसरी तरफ है। तो जब हम ये बात कर रहे हैं तो चलिए बातों बातों में ये पता कर लगाने का हम प्रयास करते हैं कि जहां हिंदू पक्ष ये कह रहा है कि यहाँ हमारे शिवलिंग है और मान्यता की अगर बात की जाए तो सबसे इष्ट देव है, और वहां भारत के ही मुसलमान ये कह रहे हैं कि नहीं, हमारा पेशाब खाना भी होना चाहिए और वजू खाना भी होना चाहिए। ये कितना सही है?
देखिए अली जनाब, मैं एक बात बहुत अच्छी थी, हमारे प्रधानमंत्री जो हमारे सांसद भी हैं, और उन्होंने एक कॉरिडोर बनाया विश्वनाथ मंदिर का, जो बहुत काबिल तारीफ है और बनारस के लोगों के लिए फख्र का बाइस है, और दिन पर दिन पर्यटन भी बढ़ते जा रहे, लोग देखने वाले उधर। तो हमारे जो हिंदू शास्त्रों के अनुसार जो 12 ज्योतिर्लिंग है, वो वहाँ उसमें एक ज्योतिर्लिंग बाबा विश्वनाथ धाम में भी मौजूद है। तो कहने का मतलब क्या, मस्जिद में क्या तलाश रहे हो? मस्जिद में क्या है? इसका मतलब वो नहीं है 12 ज्योतिर्लिंग जी, तो भी या तो ये नकली है या वो असली है। तो मैं इस पर मैं नहीं जाना चाहता। मेन पे जाना जो ही आपने दावा किया है, दावे की चौहद्दी बता, आपने स्पष्ट नहीं किया कि चौहद्दी कहाँ है। और अब पिटीशन दाखिल हो गया, कमीशन भी अभी आई नहीं, ये रोक दिया गया, वो रोक दिया गया। सुप्रीम कोर्ट ने कुछ समझा होगा, निगरानी में उनके है, इसलिए मैं सुप्रीम कोर्ट के तस्लीम करता हूँ आदेश। और सुप्रीम कोर्ट के ये आदेश पे हम लोगों ने बाबरी मस्जिद दिया जी, और
बाबरी मस्जिद दिया मतलब वो तो कोर्ट के आदेश पर हुआ,
उसी का आदेश को पालन किया ना। तो हमने
उसका विकल्प क्या था? विकल्प क्या था?
क्या विकल्प क्या था? विकल्प बहुत कुछ हो सकता था।
जैसे
विकल्प में ये हो सकता था कि हमारा जो इसके पहले की बताया गया था, सुरक्षित आपके जो आदेश सुरक्षित किए गए हैं मुसलमानों को, और उसमें बताया गया कि ये आस्था के अनुसार फैसला किया, वरना यह कोई साक्ष्य नहीं बन रहा कि मस्जिद तोड़ के बने, मंदिर तोड़ के बना है।
अच्छा,
हाँ, ये आस्था के मुताबिक हमें बांट बांट हमने मांगा था, हमने वो मालिकाना हक मांगा था, हमको हिस्सा लगा के दिया गया, 1, 2, 3 पार्ट बना के दिया। क्यों पार्ट बनाया? हम नहीं तो हमको नहीं देना चाहिए था। क्यों हमें 1 एकड़ जमीन दे दिए, वहाँ दे दिया, कोई मतलब ही नहीं था।
तो अदालत का जो भी फैसला होगा सुप्रीम कोर्ट का, वो सभी को
बिल्कुल, हम तो सुप्रीम कोर्ट से उम्मीद रखते हैं और इंशाल्लाह आगे भी रखते हैं, क्योंकि हम संविधान में बिलीव रखने वाले लोग हैं जी। इंशाल्लाह उसमें हमें कोई कभी उसमें इफ एंड बट नहीं है।
And रहिए मेरे साथ, I also have India Today's Anisha Mathur joining me on the broadcast. And Anisha, the way we look at the way the judges have opined on this as of now, this in a way is taking the middle road, ensuring that all factions, all sides move forward, seeking justice now at the appropriate forum, the district court. Anisha.
Well, yes, Gaurav, the Supreme Court has tried to sort of do a balancing act. They have said that the district judge of Varanasi will hear this matter, but the issue of maintainability of the petition, which is the plea of the Muslim side, that will be heard on priority. That the court has also said that we are not passing any orders with regard to whether or not the district judge will look into the survey report or not, because that will be a decision that the district judge himself will have to take. Secondly, the court has said that we have passed orders on the 17th of May saying that both the findings inside the premises, what is being called that a shivling has been found, that must be protected. At the same time, the district authorities must make sure that there is no obstruction to offering of the namaz, that there are adequate arrangements made for the wazu before the namaz. And therefore, the court has said that till the time the district judge here's this issue of maintainability, here's these petitions, or these orders will remain in place
Okay.
that both sides must be protected. That's it.
For joining me here on India Today, Anisha Mathur, many thanks. We went to the Kashi Vishwanath temple today and saw that entire area, the temple and what was on the other side of a barricade and barriers that had been set up. We will continue to track that story very, very closely, but that is all I have for you on this special broadcast from Avinashi, Kashi, the eternal city where thousands of on
After 2 years of paralyzing pandemic, the world is ready to bounce back. Will shifting power centers make this India's big moment? Risk, resilience and revival on the agenda. What's India's role in the global rebalance? India's top world watcher takes you to the front lines of the global high table with top minds from politics and business for the biggest global brainstorm. Live and exclusive coverage only on India Today TV.
The Taliban has good news for Afghan girls. The co-deputy leader of Taliban, who's also the acting interior minister of Afghanistan currently, Sirajuddin Haqqani, in a rare media interview, spilled some bitter beans and essentially exposed the reality of Taliban's Afghanistan for women. When asked about how women are scared to step out of their homes under Taliban rule, here's what Haqqani said. "We keep naughty women at home." I know you're all wondering, sorry, what did he just say? Well, there was a lot of outrage over his comment, so he clarified. And here's what his clarification was all about. By saying naughty women, it was a joke referring to those naughty women who were controlled by some other sides to bring the current government into question. Essentially, Haqqani was referring to those set of girls and women in the country who were protesting against the Taliban taking over the country in 2021. In fact, just a couple of days ago, Haqqani had promised very good news for girls with regards to them returning to the education in secondary schools. I would like to provide some clarification. There's no one who opposes education for women. Already girls are allowed to go to school up to grade 6, and above that grade, the work is continuing on a mechanism. Very soon, you'll hear very good news about this issue, God willing. What he's also argued is that girls right now could go ahead to primary schools, and that right now it's only secondary schools where girls can't go. Above that grade, the work is continuing in mechanism is essentially a reference to that, of girls attending secondary school. Haqqani also hinted as to what he meant about mechanism, referring that this could mean dress code and ensuring that the school uniform code is something that is in accordance with Sharia law that fits into Afghan customs and cultures, as he calls it. He also referred more broadly to the issue of women wearing hijabs, and particularly that being followed in educational institutes. Sirajuddin Haqqani is wanted by the FBI. He's been classified by the US State Department also as a specially designated terrorist. And that means that he has a $10 million bounty on his head. In fact, the first time Sirajuddin Haqqani ever came out in public was in March. But interestingly, after gaining control of Afghanistan, the Taliban had promised the exact opposite. They claimed that they'd be more liberal towards women this time around. But it was only a matter of time before they showed their true faces. The group soon reversed the decision of allowing girls to attend their classes, particularly secondary school. Afghan girls above class 6 were set to resume their school and classes in March. But then they were told to hold off. And that was essentially because the Taliban wanted to come out with a school uniform code in accordance with Sharia law and following all Afghan culture. After they returned to power, the Taliban demanded that women at least wear a scarf or a hijab to cover their head but can show their face in public. But in May, they changed that too. They've said that women should cover their faces, which means wear a full veil and preferably even a burqa. And remember that this is something that's reminiscent of what happened when the Taliban was in control of Afghanistan earlier as well. This was compulsory earlier between 1996 to 2001 when the Taliban was in control.
I have seen, storytelling changing around this topic, the subject, is that people are getting more real now. They've stopped taking those shield of either the comedy or some other things to talk about the same gender love story. Now they can directly talk about it, and we've come to that stage that okay, this is also a part of us, and love should not be told differently for different people, right? So emotions are emotions. So I guess it has come to this neutral level, and that's very interesting to see.
Make your media plan smarter with India Today Live TV on your connected devices.
You are watching India Today.
Presented by Aditya Birla Group, Big in Your Life. Co-powered by only OLX Autos gives the best price for your car. Co-powered by Panasonic Smart AC, AC for healthier homes. In association with SBI Life, अपने लिए, अपनों के लिए.
Warm welcome viewers, you're watching 7 at 7. I'm Preeti Chaudhary. The big developing story right now, Indrani Mukerjea, after spending 6.5 years in jail, has walked out on bail. Indrani stands accused of killing her own daughter, Sheena Bora. That's one of the top stories that we are tracking. We're going to get you the latest, but first up, let me take you through the headlines. Supreme Court transfers Gyanvapi case to District Court. Muslim side's plea challenging maintainability of the suit to be heard on priority. 17th May order protecting shivling will continue. Indrani Mukerjea walks out of Mumbai jail after 6.5 years, prime accused in the murder of her daughter Sheena Bora. She says she believes in forgiveness and empathy. India Today news break on language war explodes as Prime Minister Modi wades into controversy, says all languages are equal.
भाजपा भारतीय भाषाओं को भारतीयता की आत्मा मानती है और राष्ट्र के बेहतर भविष्य की कड़ी मानती है.
Karnataka superstar Kicha Sudeep speaks to India Today, hails Prime Minister Modi's unifying message, says country must embrace all languages. After the Supreme Court shot down plea, former Punjab Congress chief Navjot Singh Sidhu surrenders in Patiala court. CBI raids at 17 locations against RJD Supremo Lalu Yadav, wife Rabri and daughter Misa Bharti over corruption charges in a land for jobs scam. Indian boxer Nikhil Sareen wins big, the world champion now. All right, viewers, the top focus story is the Supreme Court's order on the entire Gyanvapi Mosque row. Let me quickly get you up to speed on what the Supreme Court delivered, a verdict which could be said was balanced in its nature. The Supreme Court transferred the Gyanvapi case to the district judge. Varanasi district judge will now be hearing the case. Now, also, the Supreme Court said that a senior judge needs to hear the case. On the other hand, the big issue of maintainability of the case will be decided on priority by the Supreme Court. Meanwhile, at Varanasi, devotees gathered outside the mosque to offer Friday prayers, but shifting focus back to what the Supreme Court said today in its order. The Supreme Court will now hear the order and the case after the summer vacations in the second week of July. Number 2, the Supreme Court has transferred the case from a civil judge to a district judge. Number 3, the Supreme Court has said the district judge now, who's a senior judge with more experience than a civil judge, will, before hearing any other petition, hear out the plea on maintainability. What does one mean about maintainability? We're going to get a larger understanding from our reporters. Number 3, the Wazu Khana will be opened, not where the shivling is there. The claimed shivling will continue to be sealed, the area around it, but Wazu will take place and the district administration needs to make sure that happens. A balanced order coming in from the Supreme Court.
अब जो माननीय सर्वोच्च न्यायालय का आदेश है वो मान्य होगा, जो देखा जाएगा उसको, जो एपेक्स कोर्ट ने जो आदेश दिया है वो उचित व जायज है. 10:15 में चूंकि सब मैंने रिपोर्ट ये सबमिट कर दी थी, उसके बाद माननीय सिविल जज कोर्ट में ये दाखिल था. उसके बाद अगर कुछ हुआ हो तो जानकारी नहीं, अभी उसके पहले तक कोई लीक नहीं हुआ था.
देखिए, सुप्रीम कोर्ट ने इस मैटर का ट्रायल डिस्ट्रिक्ट जज के सामने ट्रांसफर कर दिया, डिस्ट्रिक्ट जज वाराणसी के सामने. दूसरी बात, जो सुप्रीम कोर्ट का इंटरिम अरेंजमेंट था 16 मई का, वो होगा. तीसरी बात, जो उनका वजू के लिए वो अरेंजमेंट मांग रहे थे, कोर्ट ने कहा उसके लिए अरेंजमेंट किया जाए. पर जो 16 मई का ऑर्डर है सुप्रीम कोर्ट का उस एरिया को सील करने का, वो बरकरार रहेगा. 16 मई, हाँ सॉरी 17 मई का ऑर्डर बरकरार रहेगा. जो मुस्लिम पक्ष की एप्लीकेशन है 7/11 की, वो भी प्रायोरिटी पे डिसाइड होगी। ये 4 बातें मुख्यतः सुप्रीम कोर्ट ने आज कही हैं, और ये भी बात कही है कि जो हमारी एडवोकेट कमीशन की रिपोर्ट है वो भी उसको कंसिडर करने में कोई रोक नहीं है। उनकी एप्लीकेशन प्रायोरिटी पे डिसाइड होगी, पर बाकी चीजें भी इस समय डिस्ट्रिक्ट जज के सामने खुली हुई हैं, वो कैसे प्रोसीड करना चाहते हैं ये माननीय डिस्ट्रिक्ट जज वाराणसी का अब प्रेरोगेटिव। 7/11 की एप्लीकेशन होती है, जो मुस्लिम पक्ष का ये कहना था कि जो हमने सूट फाइल किया है वो मेंटेनेबल नहीं है, वो सूट चल नहीं सकता है। उसके लिए उन्होंने 7/11 की एप्लीकेशन डाली थी, मतलब इसको इमीडिएटली रिजेक्ट किया जाए। तो कोर्ट ने कहा है कि डिस्ट्रिक्ट जज वाराणसी उसको कंसिडर करेगा, और जो बाकी चीजें हैं वो भी कंसिडर की जाएंगी, और ये ही 7/11 का मतलब है मेंटेनेबिलिटी ऑफ द सूट का।
उनका आधार क्या था? क्या प्लेस ऑफ
उनका ये आधार था कि ये सूट प्लेसेस ऑफ वर्शिप एक्ट से बार्ड है। तो माननीय सुप्रीम कोर्ट ने कहा कि वो बार्ड है कि नहीं बार्ड है, ये डिस्ट्रिक्ट जज वाराणसी देखेंगे, उस पर अभी हम कोई कमेंट नहीं करना चाहते हैं। और ये जो SLP है पेंडिंग है, ये जुलाई में 2nd वीक में लगेगी।
All right, there are 3 big developments there. Like I said, the biggest development is that the district court, once it starts hearing the case, which will happen as soon as the civil court transfers all its files to the district court, the first that plea they will hear is on the maintainability of the case, which means that under the Places of Worship Act 1991, should this case be heard at all. The Supreme Court, on the other account, will reconvene after the summer break and hear the case in the 2nd week of July. Let's now quickly shift focus to the other big story that we are tracking, viewers, and that is Indrani Mukerjea walking out of jail after 6.5 years in prison. Indrani Mukerjea is out on bail. She stands accused of murdering her own daughter. Now, the former TV tycoon Indrani is a free woman, at least for now, accused of murdering her daughter. Indrani walked out and returned to her home, Malo, in Mumbai's Worli. Right after walking out of prison, India Today was the first channel that she spoke to.
Yes, Indrani, really all the best to you for this. Thank you. But I wanted to ask you do you blame anyone for this particular incident? It's all, it's all forgotten. 6.5 years of yours lost.
Empathy and forgiveness. I've forgiven all the people who have hurt me, that's all. So, no blame.
Is there anything you learned in the jail, prison?
Lots.
What?
Lots. Next interview.
अभी फिलहाल हम उनके घर जा रहे हैं वर्ली में, एंड वी आर रियली हैप्पी शी इज फाइनली फ्री आफ्टर 6.5 years. Really happy.
That is coming in. Indrani walks out of jail after 6.5 years, accused of murdering her own daughter. She spent 6.5 years in jail. The former TV tycoon walks out on bail. That's the latest that we are getting in. Visuals of Indrani coming out of jail. She's now temporarily a free woman, stands accused of murdering her own daughter. A lot has gone down in her own life over the last 6.5 years. She's divorced from her husband, Peter Mukerjea. Her other daughter doesn't want anything to do with her. She's a lonely woman, but Indrani Mukerjea now is out on bail. She says that she looks at empathy, she looks at forgiveness. Once again, listen in to what she said.
Yes.
Indrani, really all the best to you for this.
Thank you.
But I wanted to ask you do you blame anyone for this particular incident?
It's all, it's all forgotten.
6.5 years of yours lost.
Empathy and forgiveness. I've forgiven all the people who have hurt me, that's all. So,
no blame. Is there anything you learned in the jail, prison?
Lots.
What?
Lots. Next interview.
अभी फिलहाल हम उनके घर जा रहे हैं वर्ली में, एंड वी आर रियली हैप्पी शी इज फाइनली फ्री आफ्टर 6.5 years. Really happy.
All right, let's quickly move on into the last news break that we are getting in. Well, after surrendering At the Patiala court, Navjot Singh Sidhu has now complained of chest pain. What does this mean? I'll take you back on the excuse that Navjot Singh Sidhu had given yesterday, where he had said he needs some more time to wrap up certain health issues. Navjot Singh Sidhu's lawyer had said that yesterday, that he wanted more time. However, today he did decide to surrender at the Patiala court. He would have been lodged at the Patiala jail. But now Navjot Singh Sidhu has complained of chest pain. These were visuals, viewers, that you're getting in. He was taken in, arrested. First, he was taken for a medical checkup. After that medical checkup, Navjot Singh Sidhu has now complained of chest pain at the medical checkup. All of this coming in at the back after he surrendered in court. Well, it does seem, viewers, that this is a desperate bid by Sidhu to avert an impending arrest, because he clearly has absolutely no legal options left anymore but to file a curative plea. All of this after Sidhu earlier sought more time to surrender, citing medical reasons, but the Supreme Court bench asked him to mention the issue before the Chief Justice bench. Before the bench, senior police officials say a police team will continue to follow Sidhu even after his surrender. Meanwhile, the cops will intimate jail authorities to make arrangements for lodging Sidhu. Navjot Singh Sidhu seems to have chosen Patiala jail, which is considered... Well, he would be lodged at the Patiala jail primarily because the crime was committed in Patiala. The road rage case dates back to 1988, when Sidhu got into an argument with a Patiala resident over a parking spot. Sidhu allegedly dragged him out of his car and hit him. The man later died when he was brought to the hospital. However, this was a case that has dragged on for 33 years, viewers. It happened in 1988. A sessions court acquitted Sidhu. Then the family of the deceased approached a higher court. The matter came up to the Supreme Court, and the Supreme Court in its first hearing just fined Sidhu 1,000 rupees and absolutely no sentencing. But the family doggedly stuck by asking for a review, and now Navjot Singh Sidhu has been asked, clearly ordered by the Supreme Court, the sentencing of 1 year of rigorous imprisonment in jail.
कांग्रेस से बड़े लेट आए सर, लीडर नहीं पहुंचे अभी तक, बड़े लेट।
कोई पहुंचो ना पहुंचो, साडा काम है, ਅਸੀਂ ਪਹਿਲਾਂ ਵੀ ਸਿੱਧੂ ਨਾਲ, ਅੱਜ ਵੀ ਸਿੱਧੂ ਨਾਲ रहांगे।
एक अच्छे पॉलिटिशियन की जिम्मेदारी बनती है कि शहर में जो है उनको बता दिया जाए और वो बाद में आके मिल सकते हैं। इतने साधारण तरीके से जाके वहाँ सरेंडर कर देना चाहिए था। इसमें कोई अचीवमेंट नहीं है।
ਇਹਦੇ 'ਚ क्या बुराई है? जो कोर्ट ने फैसला दिता उन्हें मनना चाहिए। बुराई की कोई बुराई नहीं है।
कांग्रेस पार्टी के लीडर हैं, हमारे अध्यक्ष रहे हैं, हमारे मित्र हैं। अगर उनके किसी पे कोई मुसीबत आती है तो साथ खड़े होना चाहिए, रहना चाहिए कि नहीं रहना चाहिए। सिद्धू साहब ने बोला है कि आई बो बिफोर दी मैजेस्टी ऑफ लॉ। कानून जो सबसे ऊपर है, जो कानून ने कहा है सबको मंजूर है जी।
राजनीति के अंदर एक सबक है कि व्यक्ति जितना मर्जी इन्फ्लुएंशियल हो, जितना मर्जी बड़ा हो, जब कानून का काम होता है वो सबके लिए बराबर होता है। कानून सबको एक नज़र से देखता है। दूसरी बात, राजनीतिक लोगों को, सामाजिक लोगों को, सेलिब्रिटीज़ को गुस्से या आवेश में आकर अपना होश नहीं खोना चाहिए।
All right, viewers, let's cut across right now to the state of Assam. Once again, completely inundated. A flood in Assam where 26 districts completely underwater. This is a ground report.
Floods and landslides wreak havoc. Over 4 lakh people in 26 districts affected. Several lives lost, many more at risk. Situation continues to remain grim in Assam. New half-long railway station in Dima Hasao district now completely submerged in the debris from a landslide. Images of the station that went viral revealed the true horrors of Assam floods. India Today reached ground zero for first-hand account of the destruction in the area.
This is Dima Hasao, the district, and the road you see is taking us to an area called Haflong. But as you can see, half of this area is completely, the debris is still over here. We do not understand whether this is a fresh one because the water is still receding. It's coming down towards the valley from the hills. This debris is still around.
नहीं नया है
ये नया है
नया है
कब हुआ
हाँ ये इसको मैंने 2 दिन हो गया ना क्या इतना 2 दिन हो गया 2 दिन हो गया
अभी तक साफ नहीं किया
हाँ
अभी तक साफ
नहीं किया अभी वो कर क्या ना किया अबे कहना है सब खोना है
The state agencies are working round the clock to clear tunnels and roads to ensure that essential services reach the people.
This road, this tunnel that you see behind me takes us to Silchar, but 24 hours back this was completely blocked. The simple reason is because of the landslides that took place over here. As you can see now, these vehicles are moving thanks to the state government's JCBs that have been clearing these roads so that vehicular movement can resume in a normal way.
The Jorhat District Administration sent
I will not talk about the case. খুব ভালো লাগছে বাইরে এসে খুব ভালো লাগছে ফ্রি লাগছে এখন
Indrani, you will not be able to speak to Vidhi right now.
No,
You're the last
I can't.
life, so
Not right now, but I can speak to her once she deposes. So, I will request the court to make her depose as quickly as possible. हिंदी में ये वो पूछ रहे हैं कि मैं विधि से अभी बात नहीं कर सकती हूँ तो मैं जब वो डिपोज करेगी उसके बाद बात कर सकते हैं वही बोल
आपको जमानत 6.5 साल बाद मिली है
जी
आपका क्या एक्सप्रेशन है पहली
हाँ जी बोलिए
6.5 साल बाद आपको जमानत मिली है खुली हवा में आप आई हैं क्या भाव है किस तरह की खुशी है
खुशी तो बहुत हो रही है अभी कुछ और दूसरे इमोशंस है नहीं खुशी बहुत हो रही है लेकिन सबको इंडिया के कानून के ऊपर भरोसा रखना चाहिए भले थोड़ा टाइम लगे लेकिन न्याय है
জীবন কে নতুন ভাবে সাজাবে নতুন
জানি না এখন কিছু জানি না
Yes,
I know Yeah, I know
आपका प्लान क्या होगा
अभी कुछ प्लान नहीं है अभी कुछ प्लान नहीं है फिलहाल
जेल के दिन कितने बुरे रहे
Are you writing a memoir or something?
Not a memoir, I'm writing something.
A book?
Yeah.
Something is cooking.
Yes.
इंद्रनी जी आप बुक लिख रही हैं आपका जेल
What is it about?
नहीं जेल के बारे में कुछ नहीं लिख रही हूँ मैं अभी फिलहाल
किसके बारे में लाइफ के बारे में
6 साल बाद घर पहुंची है तो क्या
बहुत अच्छे लग रहे हैं
मैम पहले 6.5 साल पहले की समय और अब के समय में आप बाहर निकली हैं कितना कुछ बदल गया है
अभी तो मैं गाड़ी से अभी जेल से यहाँ आई हूँ तो अभी तक तो मालूम नहीं है अभी बाहर देखेंगे क्या
अपने
क्या
घर के अंदर आपने जब एंट्री की तो किस तरह से महसूस हुआ घर खाली खाली लगा
फिलहाल कुछ महसूस नहीं हुआ अभी दोनों साथ है ना तो इसीलिए अभी खाली नहीं लग रहा है नहीं वैसे तो नहीं है हाँ सजा हुआ है
What will your book be about? That is not about the jail.
It's not about the jail. You'll read it. I'll tell you closer to the time.
मैम थोड़ा सा आगे थोड़ा आवाज का प्रॉब्लम मैम थोड़ा सा आगे थोड़ा सा आगे थोड़ा सा
माइक है ना हाथ में
हाँ जी बोलिए
लाइफ के बारे में आगे क्या सोचा है
कुछ नहीं सोचा है अभी फिलहाल कुछ नहीं सोचा है फिलहाल केस लड़ना है
Indrani, it's already been 6.5 years and the trial is not proceeding. Would you request for a speedier trial?
My lawyers will do what they have to do. Regarding the case, I don't want to talk about anything right now. I cannot talk about the case right now. The matter matter sub judice. Any questions regarding the case, you can speak to Sana.
इंद्रानी जी, आप जब जेल में थी तो एक इंस्पेक्टर आपको मिली थी, कहा था शीना बोरा जी।
अभी मैं वो केस के बारे में कोई बात नहीं कर सकती। जो कुछ भी आपको पूछना है इनसे पूछिए।
आपके जीवन में आए परिवर्तन में बताइए। 6.5 साल तक आप जेल में रही हैं, पहले आप किस तरह थी, अब क्या
एक बदलाव है आप में? You feel a change in yourself? No, I think I have seen, life from a different lens now, because I've met people from all walks of life, and it's a journey. Like I said, it's been a journey, and of course I've learned to be more patient. You have to be patient, and more empathy, and I don't know if I've said.
All right, viewers, Indrani Mukerjea right now speaking to the press right after coming out, walking free after 6.5 years. She says she's looking at forgiveness, she's looking at empathy. Once again, let's try and listen in.
हाँ, मैं यही बोल रही थी, उन्होंने ये पूछ रहे थे कि अभी जेल में क्या कुछ एहसास हुआ है, ये कि ये जो एक जर्नी थे, अभी वो पास्ट है, अभी वो टाइम बीत गए हैं, लेकिन वहाँ पे भी मैं बहुत लोगों से मिली, अलग अलग ये से आए हैं जो लोग, तो उसमें हर इंसान में एक चीज़, हाँ बहुत बड़ी चीज़ मैंने देखी कि हर इंसान में बुराई है तो अच्छाई उससे ज़्यादा है। भले वो क्रिमिनल हो, भले वो पुलिस ऑफिसर्स हो, वो अच्छाई, हम सब में अच्छाई खोज सकते हैं, और सब में अच्छाई कुछ ना कुछ अच्छाई है, वो मैंने जेल में सीखा। Okay. So I have met a lot of people in jail. Okay, a lot of people, maybe they are innocent, maybe they are not, but I've seen in the hardest of accused who have come in, there is some goodness in every human being. At least I was in a women's jail. I can only talk about the women I met. Yeah, so even I remember everybody. As of now, I remember everybody. But I think there is good in everybody. So we just need to.
एक वक्त आया कि पूरा परिवार आपका अलग हो गया, बिछड़ गया। मैम, एक वक्त ऐसा आया कि पूरा परिवार आपका बिछड़ गया।
हाँ, क्या बोल रहे थे आप?
ऐसा वक्त आया आपके जीवन में कि पूरा परिवार ही बिछड़ गया।
वो तो होते हैं ना, जेल जाने से सबका होता है वैसा, वो तो हो ही जाता है ना, वही सबसे बड़ी बात तो वही होती है ना।
But don't you hold anyone responsible for this? For setting here, shattering your entire life?
See, the thing is, like I said, it's all forgiven. So I have moved on. And once you forgive, you free yourself.
Many time and again you've been saying that Sheena disappeared. You still believe that
I will not talk about the case.
Nothing about the case.
Whatever I have to say, I will say it in court. Because the matter is sub judice. So you can ask me about anything else apart from the case. I will answer.
Just one more time about your future plans. Just one more time.
I really don't have any plans.
What would you book?
All right, viewers, Indrani Mukerjea walking out of jail. She says she's looking at empathy. She says she's looking at forgiveness. She also says she will not talk about the particular case in question. What is the case, viewers? Indrani Mukerjea stands accused of murdering her own daughter. Trust India Today to get you the latest on this developing story. We're going to go into a quick break. Stay with us.
Make your media plan smarter with India Today Live TV on your connected devices. Amplify your brand with 100 million smart internet viewers. To advertise, mail us at sales@aajtak.com or call 9999892171.
city of Mariupol in Ukraine was always on Russia's agenda, and they bombarded Mariupol down to rubble. But even then, Russia has still not been able to gain access to the Mariupol port because of the Sea of Azov, which stands between Ukraine and Russia. And that Sea of Azov is laden with sea mines, which were laid there as far back as the Second World War. This was basically a military strategy to avoid a Russian naval invasion. So the entire seawater was embedded with mines. By the looks of it, the port will not be functional anytime soon. Now, Russia has appointed a demining department which has about 120 specialists working just on this region. That is how desperate Russia is to get to the Mariupol port. And these specialists are working on land and water across captured territories. Now, one of the commanding officers of this demining operation stated that as many as 10,000 of these sea mines have already been extracted from the Sea of Azov. But there is no certain figure as to how many more sea mines still stand between Ukraine and Russia as far as the Mariupol port is concerned. The demining team will be doing a thorough sweep, clearing the city block by block. So it is evident how important and strategic the Mariupol port really is. But why? All the wheat, steel and other items are transported from this port. So the mines in the water have thrown a wrench in the Russian plan. Until the waters are demined, the port here cannot resume operations. Now these old mines will either have to be extracted or they are going to be deliberately detonated in the water for safety reasons. Nevertheless, these mines are extremely dangerous, and here's why. Apart from the fact that these sea mines can obviously explode, the other concern is that seafarers will have to take a longer route. Turkey on the other side is also extremely concerned about these sea mines because a lot of them have drifted apart and entered the Black Sea, which is obviously bordering Turkey. So if you see the way Sea of Azov and Black Sea have been located, the mines are very much infesting Black Sea as well. So basically that means is that it's not just Mariupol port which is affected. All the ports around the Black Sea are also going to get affected, and the vessels bringing in goods could also become collateral damage. The International Transport Workers Federation Union said that it is essential that the world's seafarers can continue to perform their duties safely and keep global supply chains moving.
You are watching
This is Elon Musk. For some reason, he's sharing a console with Homer Simpson.
His mind is as rich as an Italian wedding soup.
Listen, we need your help.
Rick, Morty, why me? Did something happen to Elon Musk in your own reality?
No, he's fine.
Co-powered by Dish HD, Cricket Castly partner. In association with Philips Beard Trimmer. Adapts to you.
Warm welcome, viewers. You're watching To The Point. I'm Preeti Chaudhary. The big story of the day, well, there have been many today, but the biggest was the Supreme Court's order, which came on Gyanvapi. But there was other big development which has sparked a massive political debate. What was it? Well, it was an event. A location was Jaipur. The event was the BJP top brass brainstorming meet to strengthen the party. The agenda in question was 25 years roadmap for the Bharatiya Janata Party. The Sutradhar was stitched together by the Prime Minister, addressing the BJP top brass through video conferencing. The star performer, the star campaigner, Prime Minister Narendra Modi, while setting the 25-year plan for the party, tore into the opposition on 2 counts.
कि जो लोग विकासवाद की राजनीति से बच नहीं सकते, मजबूरन विकासवाद में आना ही पड़ रहा है, तो उन्होंने राजनीति में विकासवाद को भी विकृति के दिशा में धकेल दिया है। ये राजनीतिक दल तत्कालीन लाभ के लिए, फायदे के लिए देश के उज्जवल भविष्य के साथ, राज्य के उज्जवल भविष्य के साथ, देश की युवा पीढ़ी के भविष्य के साथ खिलवाड़ करते हैं।